Good morning, good morning, good morning. Amazing law nerd. It's Wednesday, it's February 4th. I can't believe it either. Emily, are you going to say that all year? Probably. No, I'm probably going to say that all year because trial feels like a time warp. And you know that I have the very spicy ADHD that with the time blindness and the whole thing so that time is a full construct. And it just doesn't feel A, like it's February, B, like we just finished a trial, and C, like we have another trial literally like running down the track at us. So today we are going to catch up on some of the things going on in the Kouri Richins case. They are beginning the very initial phases of jury selection, which means they are going through all of the questionnaires. We heard the judge talk about how many questionnaires that he was sending out, and it was like thousands of questionnaires. Emily, are your ears already fighting with you? Yeah, it's fine. Everything's fighting with me. Everything's like, girl, we're ready. I know. If you know, you know. I know. Of course they are. Look, in-ears, behave. They're fighting with the hoodie. So we have cables. Just is going to be what it is. So they are starting the very initial phases of jury selection where they're going through all the questionnaires, and the questionnaires being like, I can't sit on this jury because whatever. Or, oh my God, I am totally a law nerd, which is going to happen in some of those questionnaires. They're sending out so many, it's just going to happen. It's just going to happen. So they're going through all the questionnaires. And in going through all the questionnaires, they are going to start going through who's coming in to do in-person voir dire, or as Utah allows for, Zoom voir dire, which I don't even understand. I can't wrap my head around how that works. A lot of voir dire is literally vibes. Emily, you say law is not vibes. Some of it is. And some of voir dire is vibes. I don't know how you do that, like, over Zoom, and when you don't have, like, the jurors that might be the jury together in one place. But, you know, I'm one of those seasoned, not seasoned attorneys. I'm teasing. We were doing some updates yesterday in the members only, and I'm not a seasoned lawyer, came up more than once, but it's hard for me to conceptualize, especially maybe since I don't have a mind's eye, what it's like to be like, okay, well, this is juror number 1, and this is juror number 2, and this is juror number 3, and they're all sitting in the jury box, and you can see them and be like, this group is a vibe. These are my people. Let's ride. Or, number 8's not going to play well with the group. Number 8, you're out. Number, 27 that's sitting in the next seat, you're in. Because in jury selection, you would see the 12 that are in the box, and then you would see the next like 6 or 10. And then you would be able to see, okay, well, if I get rid of this juror, then the next juror coming up is this one sitting here. And that's what I'm going to do. So with that, they have the ability to do Zoom voir dire, but you just do one at a time. And how? So they're starting to pull out the questionnaires to see who's coming in next week. So jury selection is scheduled to take 2 weeks in the Kouri Richins case. The judge is not doing jury selection on Friday. It seems like they're going to start in person on either the 10th or the 11th. Emily, you have an official date on the docket. I do. I forgot to pull it up and look at it. The 11th. They officially begin the 11th. But trial begins the 23rd. Trial begins February 23rd. But you guys, how can we start another trial on Banfield's birthday? Who are we? Bring cookies. We're starting a new trial on the 23rd. Do you guys remember Banfield's sentencing date? Remember how Banfield's sentencing date is set for May 8th? Do y'all remember what day Kouri Richins was arrested on? Yeah, I didn't either until I was pulling court documents to talk about today. Kouri Richins was arrested on May 8th. Yeah, she was. It's not even a joke anymore. The way that everything just overlaps and interconnects is wild to me. If anyone says cookie in the Kouri Richins trial, I might get out of my chair and run away. I don't know. The weird connectedness is wild. And if you're new to the Kouri Richins case, hi. I'm going to do a quick road so far. But Kouri Richins didn't have an au pair, definitely had a side piece, and seemed to have been texting her side piece, baby, I love you. Baby, we're going to be together. Baby, just wait till Friday. Her husband was killed in the early morning hours of a Thursday into Friday morning. So, I mean, she had to write a whole children's book about it. But there are some parallels here that we're going to be talking about as we get into this case. Other things that are coming up. Everybody who's worried, don't worry. We previewed a Ron update in members only yesterday. We are going to add a Ron update. Today was not the day. We're going to add a Ron update. Don't worry. We're going to add a Ron update. Then for all of you who are like Emily, who don't worry, we'll get caught up. We're going to do a road so far on Kouri Richins today. We're going to catch up on the filings because her defense attorneys are just trying it. And I am so over it. There's not going to be any hiding that I'm kind of over it, but we're going to talk about it. Tomorrow, we are going to catch up on other cases. I haven't decided which ones yet. There are a couple. Then as we get into next week, we have the Supreme Court appeal for Alec Murdaugh, and we are going to probably do that on a little bit of a delay, but same day, because sometimes EDB has priorities. And the priority the day of the Alec Murdaugh appeal is concert tickets for my kiddos. So I'm going to be at a concert the night before, so I'm going to push that stream back just a little bit. Because the whole family's going to a concert. Look, I have hit the phase of senior year where I feel like I can actually count down the days that my senior is still going to be in the house. So I can't talk more about that. The eyeballs said no. So we have concert tickets. And so we're going to do Murdaugh. Murdaugh can wait a minute. He's been waiting for this appeal for like a fucking year. We can wait a few hours. It's going to be fine. And if you want to watch it twice, that's amazing. So everybody's going to the show, which is kind of a big step for my younger one who that sensory experience is not always for him. And he's super excited. I've never been happier. So we're doing that. I'll share more about that after concert. And we'll see how it goes. Could be amazing. Could be a problem. But we got earplugs for everybody. Think it's going to be great. Very excited. So we're going to cover Murdaugh's appeal. We're going to cover some more of the Banfield evidence. Honestly, I needed a minute to not look at Banfield's face. I needed a minute to not look at Banfield's face. And then I have seen some confusion about Juliana's sentencing. But I went to the court docket yesterday and went through the court docket, and I found where the confusion was on Juliana's sentencing. Here's where the confusion is. Juliana's sentencing date had been set for February 20th, 2026. The court moved it up sooner. So on the docket, it's a little confusing, but the court took the February date and accelerated it and just moved it closer. So her sentencing is supposed to be on February 13th. So we are going to take a look at covering her sentencing on February 13th. And, you know, as we lead up to her sentencing, we'll read some of her baby I love you letters because we know there's a bunch of stuff from February 13th. So we're going to do that. That's kind of what's roughly on the docket. We have some other cases that have things going on, and then we will try to cover them before opening statements begin. But we've also got a lot to cover in like barely 2 weeks before the Kouri Richins case starts. And also, your girl needs a little bit of sleep, just a little bit of sleep before we get into what looks like it's going to be maybe a 4 or 5 week trial. The judge has set aside for this trial from opening statements February 23rd through March 26th. Just get ready. Just get ready. Just get ready. We got a long trial coming up. Yep. We got a long trial coming up. And we've got a lot of cases that are going to take some time. Some of that's going to be on the podcast. Some of it's going to be here. All right. Y'all ready? Let me know what you're drinking or snacking on in the chat. We've got chat. We've got coffee. We've got court documents today. We've got court things, everybody. Let's go. Hey there, I'm lawyer and legal analyst Emily D. Baker, and this is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time so you know what's happening. No law degree required. So join the law nerds in the chat. They're here for the facts, not and let's get to court. All right, chat. For those of you that are new to the Kouri Richins case, I am going into this case without a lot of warm feelings. We have been watching this case since Kouri Richins' arrest because, well, at the beginning of time when this case started and she was arrested, they did a really extended bond hearing with like witnesses and evidence and all the things. And at the point that they were like, so she wrote a children's book about grief and was on a book tour in the year after her husband passed. And now she's been charged with his murder. But also, she didn't know that her husband had changed his will to establish a trust that his sister was in charge of. And then when she found out, she throat punched her sister-in-law when they were fighting over taking money out of his safe in the very brief days after his death. I was like, excuse me, what? What did you just say? And then as we got into more information about this case, I was like, you've got to be kidding me. So I was in at the beginning. I was like, I'm in. I don't know what craziness is happening, but I'm in. And then we started seeing the information about the Google searches. And then fairly early on in the case, we got that walk the dog letter. You guys, it's just a novel. It's just a story. And then we had some of those like amazing like jail calls because like the prosecutors are like totally the worst. And like, they just like don't like understand like how hard it is to be me. Like I need the Crest white strips. I'm sure my attorney won't mind. Mama, can you just like put some Crest white strips in an envelope and give them to my attorney Sky? Like, she totally will smuggle contraband into jail. She won't even mind. She'll totally fucking mind. Sky's no longer her attorney. Not because of that, but this is what we're dealing with. We're dealing with, like, how do you pass a lie detector and luxury prisons for rich people and how long to inherit? And while I will make fun of the luxury prisons for rich people because, girl, that doesn't exist. Well, I guess there's an argument about federal minimal security prisons. I suppose there's an argument to be made about federal minimal security prisons, but I still don't think luxury is the correct word. Less terrible, maybe. But, you know, Mom can't be in jail with the poors. This is Kouri Richins. My sister-in-laws are so jealous of me because I'm just better than them in every way. So when we talk about this case, I just want to remind everyone, because this is how I remind you, that I'm going into this case with more of an opinion than most of the cases we have covered. If the prosecution does not deliver the things that we think that they are going to deliver, I will be furious with Mr. Bloodworth. But if we see the evidence come in the way we've seen it before, I already have an opinion. I'm keeping my mind open. If they can't prove it, then they can't prove it. I can actually look at, oh, we know this outside of court. We know this inside of court. What happens inside of court might not be enough for a jury. What happens outside of court is totally different. But if her argument is going to be this was an overdose, there is nothing in this case from what we have seen that indicates an overdose. Nothing. And if what her lawyers are going to argue is, but you guys, you don't know if she put fentanyl in his Moscow Mule or in a lemon drop. Sure. That's an argument. That's an argument. I'm not persuaded by that argument. That's not how ODs work. So, the things I'm interested to see is how are they going to get into statements that the decedent Eric Richins told friends. There are some other statements that they are fighting to get in with exceptions to hearsay. There are some nuanced areas of hearsay that they are working on. The judges just asked for more briefing about it because there are things like excited utterance, et cetera, that they are working with to get around the rules against hearsay. Well, that sounds like it's nefarious that they are using to find an exception to the rules against hearsay. There are many, many exceptions. You just have to fit within that circumstance. And I'm interested to see how the hearsay works out. And I know there's things that we still don't know. One of those things is her journal. Her journal was the subject of a lot of fighting when they did the motions to suppress. Inevitable discovery ended up being the way that the journal is coming in, not all of it. But the first couple pages, apparently she journals about the night of the crime. And in my brain, that goes something like, Dear Diary. The fake news says that people are just dropping dead from saying the word fentanyl. And that's not true. Because on Valentine's Day, he 100% did not die. What is this misinformation about how fatal this is? Because I had to ask for more, and I had to ask for something stronger. Yeah, she's charged with attempted murder from Valentine's Day, February 14th, Valentine's Day. It's going to be interesting to see how that comes in, how they bring in experts to talk about opioid reactions and the information that we have from Eric Richins and from Eric Richins' two friends about what he was experiencing. He told her that he was feeling incredibly sick, and she's like, just go lie down, like full Goodbye Earl style. Just go lie down. It'll be fine. And then 2 weeks later, he was killed with a substantial amount of fentanyl in his system. Fentanyl is, by the way, incredibly deadly and terrifying. And that is actually true. But Kouri went to the person that was bringing her narcotics and asked for something stronger after February 14th, which is where my brain runs away with. But they keep saying it's so dangerous. Also, we've read the jail calls. So there's a voice that goes with the jail call transcripts. So I'm going into this with an open mind to see what the evidence is, but also I don't have nearly as many questions as some of the cases we've gone into. That might change based on the evidence in front of the jury, and I will be working to parse the two. But yeah, I don't think this is an overdose. I don't think this is an overdose. Nope. So we'll see. Does that mean the prosecution can prove it to the jury? Not necessarily. And I am incredibly biased towards this judge. I love this judge. This is the judge with the deep, 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 deep voice. Sometimes a beard, sometimes not a beard. This is the judge. This is that judge. And he approved streaming. So, yes, Judge McSteamy voice. Judge M, Judge M, Judge Audible, Judge read all the books. Love this judge. Also, he's been incredibly fair. He's been incredibly diligent and incredibly conscientious. And he's been so just even keeled. He is just a very consistent, this is what I love from a judge, a very consistent presence, incredibly fair, and rules from the bench, incredibly prepared. He hears the defense, but when it's time to say, no, we're not, no, we need to bring it down. I need you to answer these questions for me. Love it. I like the way he handles his courtroom. I love everything about it because he just keeps things moving along. I do not love and have much shade for how much this judge allows them to seal. Your Honor, stop it. He seems to be very, very, very concerned, very, very concerned about what information might get out to the media. And here's where I take issue. The defense keeps leaking things to the media, things that are sealed. I have seen media reports. From this case of exhibits that are sealed on the docket. If things are required to be sealed, why are they getting leaked to media outlets? And the media outlets say provided to us by the defense. Okay, then why did the defense seal them? One of those motions we're going to hear today. So, no, chat's like they can do that? No, but they do. And what's the court going to do? The reason the court has sealed so many things is to protect Kouri Richins' right to a fair trial. The state also has the right to a fair trial. And funny enough, the things that are being released are things that I would guess the defense feels are unflattering to the state. And I hate it. If things are sealed, things are sealed. I hate how much has been sealed. I don't think it's open and fair access. I can see where the court is going with that. I get it. They will be unsealed later. But to seal things and then have the defense leak them, or to seal things and say that nobody can speak to the media and then the defense gives a sit-down interview and is like, but we need a different narrative out there. Miss me. It's just not equitable to be like, okay, prosecution, you can't speak. We can do whatever we want. Either everybody's going full don't speak. I know what you're saying. Or everybody can speak. But it can't be a sword and a shield. That's not equitable. And I don't like it. So we will see. Crafty Sewist, question, do we know who has the children? Yes, Eric Richins' family has the children. They are with, I believe they are with the sister who was in fact throat punched. I think that is actually the sister they are with, who is the executor of the estate. But I know that they are with victim Eric Richins' family. And I'm not going to look further into that. A, it's none of my business. B, I just hope that they are well. But they are with Eric's family. He had multiple sisters. I'm not sure exactly which sister that they are living with, but they are with one of his sisters. So I'm glad that they are with their father's family, but they are not with their mother's family. So I know the sense of justice in the Law Nerd chat is high. I get it. So are we ready to look at what the defense is trying to do? And for those of you that are watching the Robinson case out of Utah, yes, these are the same defense attorneys. Yes, it is. Yes, it is the same defense attorneys. These are defense attorneys who are privately practicing, but can be appointed by the state. So they are like contracted in. So these are not public defenders, but they are appointed counsel. So They are appointed counsel. All right. Does that make sense? Great. Let's pull up our docket today. Let's talk about what's on the docket today so we can timestamp it so everybody who wants some Zoom room has the Zoom room. All right. Today we are going over the defense's renewed motion to reconsider change of venue. Do you remember the 21st day of September? Yeah, that's the kind of day it's going to be. Do you remember the first time the defense did this? And then it got appealed, and then the case got put over forever? Right. And then the judge was like, no, we're not doing that. They are trying to make another motion for change of venue. It is more timely, and I will talk about why I think it's more timely as we get into it. We are also going to be talking about the defense's motion to, well, let's do this. We'll do that one first. The defense is still asking to compel communications, but the defense is also alluding to the fact that the prosecution is threatening witnesses. So we're going to talk about that as well. Those are the things that are on the docket today. Lucy said, don't they already have a jury? No, jury selection has not begun yet. They have started the process of going through the jury questionnaires. They are narrowing down the jury questionnaires, and then they are going to start pulling jurors in groups for individual voir dire starting on Monday. So that's what they're doing. So let's just go through the recent docket that we have not seen yet. We're going to start with the defense's motion to compel disclosure. This is the docketed item that I take some particular issue with because some of the things have been leaked. And I have to decide if I actually want to go to the media and look at the things that were leaked, or if I'm just going to be salty about it and be like, no, that's not equitable. Amanda, so what Amanda is saying in the chat is, EDB, I just finished Butcher and Blackbird. I'll never be the same. So no more ice cream then. Amanda, no more ice cream? Is that what you're saying? I think that's what you're saying. That's okay. Yes, and that will wear off, I promise. It will, I promise. Everyone in the chat who's like, Emily, what are you talking about? This one is a proceed with caution, law nerds. Just know yourself. If you have no idea what I'm talking about, probably not there yet. It's not a first step into a different realm of reading material. It's not a first step. That's all. So is it great? Yes. Is it a first step? No, not for everybody. But if it's for you, you will love it. Bryn Weaver is great. All right. Let chat. You guys are great. Yes. Yes. All right. Let us go to this first motion. We haven't swooped in about 100 years because it's just been about 100 years. Oh, Emily, swoop the next documents. We need to fly to Utah. We're still in Virginia, Emily. You've left us in Virginia. Fair enough. Draw near, and ye shall be boarded onto EDB Air. All right. Let's go to docket. All right. This was filed. Oh, where did I put the date? When was this filed? This was recently filed. There was so much filed between like January 20th and today. It was just, there were a lot of motions. This was filed January 26th. So That's where we're at. Let's take a look at this motion. Kouri Richins, through her attorneys and the rules of Utah and Giglio, submits. It's like, hey, you have to give us information. Give us information. It could be potentially exculpatory. Give us information. Submits the following motion to compel the disclosure of all recorded calls, voicemails, text, or any type of digital messages from the prosecution team or any of their investigators and or investigators from the sheriff's department and or private investigators or process servers with any witness subpoenaed by the state to testify at the trial of the matter or any witness identified as a defense witness. Do you see the ripples of the Karen Reed effect? I'm going to just start calling it that because I don't want to call it the Proctor effect, because somehow I think he would just be like, Like, I think he would improperly see that as a good thing. It's a bad thing. It's a bad thing. Law enforcement, I think, state over state, will forever refer to people getting into their personal cell phone as getting proctored. 100%. You've gotten proctored. Y'all are going to get proctored because defense attorneys are paying attention. And defense attorneys in every state are going to be like, what might we find? We saw it in Banfield. Banfield was hoping to find something of substance. And what Banfield found is, I'm working with coworkers that are morons. And don't tell the prosecutor just yet. We need to tell the chief of police first. And we'll turn it over within 24 hours. Ideal? No. The end of the world? Also no. So I think we're going to see these requests in every, at least significant case going forward. Some cases the defense is like, I don't care. This isn't going to trial. This is going to be a plea deal, whatever. But I think law enforcement, will be having these internal conversations about not getting proctored. And don't be a proctor. Honestly, getting proctor really wouldn't be a problem if you're not acting like proctor. It just wouldn't. If you're not acting like proctor, what's on your work phone? If you are being a proctor, then they should have access to your phone. So, proctor is going to be the new don't be a dick. Don't be a proctor. So, when we're looking at these requests, I do think that this is going to become much more frequent because you never know. However, there has to be a thread that opens this up. There has to be a reason this gets opened up. You can't just say, excuse me, Your Honor, I need everybody's messages with everybody. That's not proper. A lot of it's work product. So I'm curious what their thread is as we get into this motion. This is, I think, an overly broad request. Your Honor, give us everything. Give me everything tonight. Your Honor, just give us everything. We want to go through everybody's text messages. Are they calling my client everything but a child of God? What are we doing? So, they want everything. In support of this motion, the defense submits the following. Last week, the defense team received notice from one of the state's witnesses, witness 1, that she was being harassed by an investigator working with the prosecution and inquiring whether there was anything we could do to protect her from them. The witness forwarded text she received from lead detective Jeff O'Driscoll. Well, that's interesting. What texts? Also, it sounds like you already have them. So do you need them? Who immediately said, my name Jeff. We might need to put that on the soundboard for this trial, right? So the witness forwarded text. So you have the texts then. The witness forwarded text she received from lead detective Jeff O'Driscoll, attached here to as Exhibit A. Guess what's sealed? Guess what is sealed? Ding, ding, ding. The defense filed Exhibit A under seal and then gave it to other media outlets. Like, why would you do that? Just don't follow it under seal then. Because the prosecution has it and the judge has it. So if you're going to file it under seal, then what are you doing? Like, what are you doing? So let me put up a poll. All right, I'm going to put up a poll. I will let you guys decide, and I will abide by the chat rules. I abide by chat's rules. Do we go find a local media source to look at these because they got leaked? Do we just go look for it? We can. If you guys want to, we can. With the caveat that I think it's kind of fuckery, just don't seal it then. I think it's kind of bullshit. However, I think that by leaking it to the media, you can strip out the identity of the witness and still get the content of the text messages out there, which is probably their desired result. So that's what I think. All right. The witness forwarded the text messages that she received from Detective O'Driscoll, attached as Exhibit A, which is under seal with the court. Oh my God. I tried to get cat hair off of this microphone. If you are on members only, you know why. Because Fred, but there is still just cat hair on this microphone because Fred. It's going to get stuck on my lip gloss. As the court can see from the attached texts, the witness made it clear that she did not want to be quote unquote prepped by the state to testify and asked them to send her any of their questions in writing. They're never going to do that. They're never going to do that. Also, a lot of prepping a witness for trial, also not improper, a lot of prepping a witness for trial is, hey, just answer the question that's asked. Answer truthfully. Do you want to review any previous reports or statements that you made? We're going to call you to testify on this day. Please wear appropriate clothing to court. This court considers appropriate clothing to be this, that. When you are called to testify, it might be this day, but it could be a different day. This is the person that's going to contact you. This is where you park when you come to court. This is where the waiting room is when you are a witness and you're not in court yet. If you are a witness, you cannot watch this case streamed or whatever. You can't walk into the courtroom while somebody else is on the stand. You have to wait outside. There's a lot of logistical things that go into witness prepping. It is not so tell us this. It is this is how this all works. It should never be so what we need you to say is, what we want you to say is. And prosecutors generally prep their witnesses kind of broadly because one of the first defense questions on cross should be, did you talk to the prosecutor before you testified here today? And as a prosecutor, I wanted the response to that question to be controlled by me. Did you talk to the prosecutor before you testified here today? Yes, I did. What did the prosecutor tell you to say? They told me to tell the truth. They told me that if I didn't understand a question, I could ask them to repeat it or rephrase it. They said to follow the instructions of the court. They said to wear closed-toed shoes. California, it was a problem. They said that both attorneys would ask me questions. And for some witnesses, when I prepped them, because I knew the defense would ask that question, they said that I didn't have to look at the defendant if I was scared. Those are the things that I told most witnesses in court. If a witness was going to be asked to identify the defendant, and that might be incredibly emotional, I would say, I am going to ask you to identify the defendant. Would you prefer that I do that at the very beginning or at the very end of your testimony? If you do not want to look at the defendant, look at me. If the defendant is doing anything that makes you uncomfortable, you can let the court know, you can let me know. If the defendant is making any gestures at you, saying anything to you, mouthing anything to you, you can tell me, you can tell the court. But you do not have to look at the defendant. Because there were defendants that would try to intimidate the people that were on the stand, especially if they knew them. And I would just be like, lock in with me. I've got you. But if the defendant is sitting over there going like this, I need to know and I can't see them. And the court needs to know. Often the court will catch it. So that's what my witness prep looked like. Some witnesses, I didn't offer for them to see the police report. Hey, I'm not going to have you look at your police report now. If there's something you think you told the police and you can't remember, you can tell me that you don't remember now, and I'm allowed to refresh your recollection, but we'll just do it then so everybody sees what we're doing. That's it. And then I would ask them if they had any concerns. I would tell them that witness assistant could get them a voucher for lunch if they need it. We would talk about logistics. Anything you're concerned about, this is the phone number you call. If anything happens, if anything weird happens when this case starts trial, this is who you call. That's what that's what my witness prep looked like. Sometimes, I will say, sometimes my witness prep looked like, hey, we're going to be calling you to testify on this day. You've been subpoenaed. And the response would be, fuck you. I'm not coming to court. I didn't see shit. I have nothing to say. And I'd be like, cool. This is going to go great. This is going to be amazing. Fantastic. Well, I'm so sorry that you feel that way. However, you have been subpoenaed. And if you fail to appear on your subpoena, then we will issue a body attachment and we will send law enforcement to come out, and they will pick you up and give you a ride to court to make sure that you come to court. And if we don't need you that day, they will also give you a place to stay for the night. You'll get a meal. I can't guarantee it's going to be hot. It might just be a sandwich. You'll get a meal, and then we'll call you the next day. And if we can't call you the next day, then you're going to get a place to stay for the night. And then we'll call you the next day. I only had to bring a witness to court via police officer once. Maybe we'll tell that story if we have time later, because I didn't like to do it. Because I get it, you guys. I get it. There are real world consequences to going to court and testifying. And I understand when people are like, I told the police this thing happened this day, and I've now moved on with my life. And a year and a half later, you're going to drag me back into this shit, and I don't want to do it. I don't want to sit across from that person. I don't want to say what I had to say. I was scared on that day. The situation stopped, and I do not want to come to court. I do not want to make this situation flare up again. It's like shaking a hornet's nest. It's fine. And that's hard. And I have a lot of empathy for that, because at the end of the day, I can't always stop the real world consequences. We can try, but I can't. Joanna said place to stay equals hotel. No, place to stay equals lockup. Yeah, no, place to stay equals jail. Cooperative witnesses, sometimes we had witnesses that we had to rehome. The problem is, one of the cases I had where we had a witness that was that was rehomed, not really in protection because state prosecutor, not federal, but we had a witness that we had rehomed. The problem is that when somebody has something traumatic happen to them to the point that they actually need to be moved out of the area for their own safety, they have now been through something traumatic, and you have now moved them to a place that they do not know, where they have no connections, because if they have connections there, they will not be safe. And you have now taken a person who has a traumatic event, is afraid. You've moved them away from everything that they know, that is familiar, that they are used to, and moved them to a completely different part of the state, or sometimes a different state. Problem is, that is a lot for a person to deal with. To go through trauma and then be around everything unfamiliar. And so the problem we had frequently, and I had in some of my cases, was that when people would get moved, they would come back. They would come back. And it was hard because that did not always go well. And you realize, as a prosecutor, there's only so much you can do. You can offer everything in the world, but you can't make someone feel safe inside. You cannot make someone feel safe. You can try to move them to somewhere where they are safer, but you can't make them feel safe. And if they don't feel safe, they're like, well, I'd rather not feel safe somewhere I know than not feel safe somewhere I don't know. So either way, that's my diatribe about witness prep. It's a hard balance, and it can be frustrating because I get it. So the witness forwarded the text she received from lead detective O'Driscoll. I'm fascinated to see what those texts are. I wish I can say I was always compassionate. But there were times I was definitely frustrated, and I was like, okay, well, if you don't want to come to court, fine. If we don't go to trial, fine. But then this person's back out, and they're still going to come find you because they know you talked to the police because they have the discovery. Your best bet is to come to court so they stay in custody longer so you can be safe. But if you don't come to court and we don't proceed with trial, they get out of custody and they still know that you talked. And then we're going to end up here on a shooting. Can we avoid that part? I would really, really, really like to avoid that part. Can we avoid that part? All right, so let's see what they go on to say. The witness didn't want to be prepped by the state to testify and asked them to send her any of the questions in writing. They're not doing that. Detective O'Driscoll responded by threatening to get a warrant and arrest her and bring a pole for her dog if she did not come in for an interview. Okay. I feel like there's more to that. He also threatened witness one with jailing her. This is blatant witness intimidation. I have questions. You can't issue a body attachment for somebody not coming to an interview, though. Because I really wonder if this is, no, we're going to subpoena you. You are under subpoena. You have to come to court on that subpoena. And if you don't, we'll give you a ride. And then we'll give you somewhere to stay. Yeah, that's where do we balance explaining to someone the consequences that actually exist and threatening them? It's really hard over text because where is the tone? However, you have been subpoenaed. If you do not show up, this is what's going to happen. I can understand why somebody would not like those consequences, but that's also reality. It's not what anybody wants to do. All right. So the defense says this is blatant witness intimidation. I need to see the text. I have questions. Also, I can understand the fine, don't come. We'll come to you. Chad is asking, is this Kouri's mom? I wonder. I wonder. It would make sense if it is. Fine. You've been subpoenaed. You don't want to show up? We will come to you. Sure. The defense has now received communication from another state witness also complaining of being harassed by state investigator Travis Hopper and asking the defense team for assistance. Texts from investigator Hopper were produced and attached as Exhibit B. I bet those are also fucking sealed. Kathy said it just happened in the David case. Yep. And they went out of state to yoink that witness from his mommy's house. Yoink. Hey, buddy. How's Montana? Time to get back to LA. You need to appear before a grand jury. Yoink. You can either come to court or we can provide a ride and housing accommodations. You're not going to like the accommodations and you're probably not going to like the ride because they're going to put you in the back of a cop car and people pee back there all the time. It smells like, ugh. You don't want those accommodations. Honestly, I really think we could just reduce crime by showing people the disgusting things that happen in the back of a cop car and be like, do you really want to sit in that? I don't think you do. I don't think you do. I don't think you do. More practical. A couple of you in chat are like, oh my God, they pee. Oh, a lot. Among other bodily fluids, but I'm telling you guys, you take a couple in-service cop cars to a high school. You open up the doors and be like, do you want to sit in the back of that? No? Good. Let that be a reminder. Just be practical about it. All the things. I had a coworker who had a defendant actually hurl his own feces in a courtroom. I still don't know how it was accomplished. I really don't know. I don't want to know. Look, practical. You got to tell people the reality of the things. Because if that person's throwing poo in court, what do you think they're doing if you're their cellie? Also, how can you poo while you're sitting in court? Like, I just don't understand. I still don't know how it happened. I'm sorry, chat. The former astronomer said, Emily, it's dinner. It's dinner time where I'm at. I'm sorry. We're going to keep going. We're going to keep going. We're going to keep going. All right. Apparently, witness 2 thinks investigator Hopper is also threatened to withdraw the previous immunity granted to the witness and submit him to prosecution if he does not agree to come in and discuss his testimony in person with the prosecution team. If you have been offered immunity and you fail to go to court and testify, guess what? No more immunity. However, they do not, I don't think they can do that for witness interviews. For trial, they can. I don't know. Can Utah subpoena for witness interviews? Maybe they can, but generally this happens if you don't go to court. So yeah, if you have immunity and part of the offer of immunity is you have to come and testify truthfully and you're like, fuck you, I'm not coming to court. The next response is, well, I mean, okay, but there's going to be problems. I would imagine this is 100% the person we've already seen communicating with the defense that sold the fentanyl to the go-between. So in this case, there is the person who had the narcotics. They sold them to the go-between. The go-between sold them to Kouri Richins or gave them to Kouri Richins or whatever. The hand-to-hand transaction at the Maverick and Draper. Oh my God, you guys. I was, some of you have asked if I can make this bigger. I can try, but this might get really perilously close to Emily fucks with technology and it doesn't go well, but we can see, ooh, we might have some more room. We might have some more wiggle room here to make this docket a little bigger. Travis and I were traveling to do college-y things. There were Maverick gas stations everywhere. And I actually giddily went, oh my God, it's a Maverick. Travis was like, what the fuck are you talking about? It's a Maverick. He's like, call sign Maverick? I'm like, nope, gas station. And he was like, huh? And then we had a whole conversation about this case. I was so geeked. I was very excited. I was like, buddy, we got to go take pictures at the Maverick. He's like, what's wrong with you? It's -6. We're not getting out of the car. to take pictures. He gives beauty for ashes, said the dealer that denied selling fentanyl. Yes, the dealer that first said that he sold fentanyl and then said it wasn't fentanyl. It was something else. We do not have Mavericks in Tennessee. We do not. No, we don't. No Mavericks in Tennessee. We have Buc-ee's now and In-N-Out. And no AM/PMs either. I don't know if AM/PMs are only like California or just West Coast. No AM/PMs. We have Twice Daily, which is one of my favorites. A lot of Circle K's. Racetrack, which I quite like. And then Speedway that looks exactly like Racetrack. It's kind of like Texas Roadhouse and the other one that wants to be Texas Roadhouse. Yeah. All right. So investigator Hopper threatened to withdraw previous immunity granted to this witness and submit him to prosecution if he does not agree to discuss his testimony in person with the prosecution team. 2009 Dragon, I honestly have never been more sad than when they changed all the come and goes to different things. And yes, the quick stops were called come and go, KUM and go. Yeah, I was really sad when they changed all the come and goes too. I thought it was hilarious. It made me laugh every time I saw them. Every single time. It made me laugh every single time. Yeah, that for all of you that are out of the US, I understand that the regional like gas station convenience stores are a whole thing. But yes, the come and goes were for real. Yes, it was spelled KUM. No, I don't know why they did that. Yes, it's an actual store. No, I'm not messing with you. Yes, it's real. I don't know. I was really sad when they changed all the names. I was really sad. It was funny. It really was. We don't have Wawa's here either, but Mix, Wawa's amazing. We do not have the Wawa here. Yeah, the come and go was for real. It's for real. They needed a come and go in Beaver, Texas. Or Beaver, Utah. I don't think they ever had one. All right. The defense is saying that the investigators are being big mad and that witnesses don't want to be made to adhere to their subpoenas, is what it sounds like to me. Section 76-8-508.3 of the Utah Code annotated prohibits actors from making a threat of harm against a witness involved in an official proceeding. Harm includes physical, emotional, or economic injury. Damn it, it doesn't say damage. Excuse me, Utah. Can we annotate the code so it says emotional damage? Please. Just for lols, please. Physical, economic, or emotional damage, or damage to a person or his property, reputation, or business interest. Certainly, threatening to arrest someone who does not discuss their testimony prior to trial, or threatening to withdraw immunity, or threatening to harm their dog. If they threaten to harm the dog, I'm gonna be real fucking pissed. Or threatening to harm their dog would suffice as harm under the statute. Such conduct constitutes a third-degree felony. I have a hard time with what the defense says, because so often the defense says a lot of things in this case, and then we look at the thing and we're like, that's not what was said at all. Also, you've been subpoenaed. If you do not come to court, we'll get a body attachment and arrest you is a reality. We're getting into the housewives like, is that a threat? No, it's a promise. Is it fair, chat, is it fair to have a subpoenaed witness, know that if they don't show up on the subpoena, that you will issue a body attachment for them or a warrant for them and go arrest them? Is it fair to not tell them that that's what will happen next? I imagine a lot of people don't know that. Why would everybody know that? Wouldn't it be worse to be like, sure, Jan, don't show up? Then don't. We're going to subpoena you. We're going to tell you to come. See what happens. It'll be a surprise. Surprise! You're under arrest. I think you should tell them. I also don't think this is a third-degree felony because it's not like, well, we'll see what the defense says. Even if the conduct alleged herein falls short of criminal activity, it is most certainly a violation of the Victim and Witness Rights Act, codified in UCA 77-37-1, which requires the state to ensure that all witnesses of crime are treated with dignity, respect, courtesy, and sensitivity. I agree that they should be. All witnesses of crime should be treated with dignity, respect, courtesy, and sensitivity. The defense, when they start arguing in this trial, chat, make an asterisk right now. When the defense starts arguing that somehow the victim's at fault for this case and that their client did nothing, remind me again of section 77-37-1. Remind me again. Because this is a convenient argument now. I think we are going to see this change. But we'll see. But I agree. They should absolutely be treated with dignity, respect, courtesy, and sensitivity. And I think that there are times that the sensitivity part and the courtesy part 100% get lost. I really do. And it shouldn't. But I believe absolutely to be true. So, they say, finally, the fact that representatives of the prosecution team are threatening witnesses to coerce them into doing or saying things they did not want to do or say goes directly to witness credibility and to the state's knowledge of the state's knowledge of these threats must be disclosed. It sounds like you know that, though. It sounds like you are aware. So you're aware that the witness is telling you that they don't want to come to court. The question is, when these witnesses get called to court by the prosecution and Mr. Bloodwish says, good morning and or afternoon, witness, insert name here. How are you doing today? If their response to that question is, fuck you, then we'll know. Emily, it sounds like this has happened to you in trial. Yeah, it has. Sets up a delightful day at work. Because you're in court and you can't respond. Oh, fuck me? No, boo-boo. That's not how that's going to go. You can't clap back. You're just like, I get it. Like, I get it. I'm ruining your day. I get it. But also, the defense is requesting the court to compel the prosecution to disclose any and all text messages, voicemail, recorded calls, emails, or any other digital messages with witnesses identified by either the state or the defense on their witness list. All communications with everybody. No, that's not going to happen. And it sounds like they have the digital communications of the witnesses that they're concerned about, and it sounds like they're aware. And when the witness testifies, you can just say, have you talked to the prosecution before your testimony here today? All right, I'm not blown away by this, but let's go take a look. Maybe I'm just maybe I'm seeing this from the wrong perspective, and these texts are going to be earth-shattering. Let's go see if we can find them. Because polls at 86%, let's go look at them. The caveat of let's go look at them is that EDB thinks it's fuckery that they leak them. Also, if the question is, how do we know the defense leaked them? Because it is, excuse me, the prosecution's threatening witnesses. Yeah, this isn't the prosecution sharing that information. So let's see. And then we will switch to the motion for change of venue. Let me see if I can find this. Hopefully, like KSL covered it. Remember, Kouri Richins was also accused of witness tampering when she was writing the Walk the Dog of it all. All right, I have not read this article. We're going to just do this together. Question is, which browser are we going to do it in? All right, it'll be fine. Emily, still desperately seeking the proper reader mode? Yes. It's the pop-up ads that really just do me in. There's just too much movement. And then I'm like, squirrel. Squirrel. All right. This is from KSL.com. I think this is one of the outlets that has these texts because the defense has communicated with them in the past, though we're going to all find out together. And then if we need to go to a different article, we will. Kouri Richins claims the state is threatening witnesses and seeks all communications. The key takeaways, by the way, are generated by AI. It's disclosed at the bottom of the article, so we're just going to go to the body of the article. Less than a month before the murder trial for Kouri Richins is scheduled to begin, her attorneys claim members of the prosecution team have been threatening or harassing witnesses. In a motion filed Sunday, Richins' attorney asked 3rd District Court Judge M to require prosecutors and their investigator to turn over all messages. They supported the claim with screenshots of text messages from 2 witnesses. How would they know that they're screenshots? They're sealed. One who communicated with lead detective Jeff O'Driscoll, the other who communicated with the prosecution's team lead investigator Travis Hopper. The emails were provided to KSL by the defense. Chad, any speculation on why we're not provided things by the defense? Gee, Emily, I wonder. Girl, you sit here going,
Like, it's a super detailed novel. 67 pages. 67. Yeah, maybe that's why. Maybe.
Docket 214, but every law nerd on the internet calls it the Walk the Dog letter.
This is why we are not the one, law nerds. We are not the one. I appreciate KSL stating just straight up, the sealed exhibits were provided to KSL by the defense. Thank you, KSL. This is a you can't have it both ways. Will the prosecution make a motion for sanctions? They probably should. Will they? I don't know. This would piss me off if I was the prosecutor. Mr. Bloodworth, excuse me. I thought that sealed exhibits weren't supposed to be provided. Don't worry, we're going to pull the docket and I'll show you where they're sealed. Emily, that sounds petty. They found me on a good week, man. They caught me at a moment where I'm just I just am so over the fuckery. The defense has complained in this case at exceeding length about how unjust it is, how unfair it is, how rude it is. The media has said things, against her client, and how unfair the media has been to Kouri Richins, and about how she can never get a fair trial. And then is like, I'm going to put that court document under seal and then provide it to the media outlets that I think will be most friendly to me. Sure, Jan. It's just don't put them under seal. Exactly, chat. The nastiness, the rumors. Yeah. We're all gonna take some doctoral level courses at Swoops Petty University. That's where we're gonna be. I do not like this type of gamesmanship. I do not like the stunts. I do not like it. If you're gonna try your case in the media, And I have criticized this in other cases. I have criticized lawyers in other cases for the same thing. But there are lawyers who play this game very upfront and do not say, oh, but the other side can't. We saw this in the Lively Baldoni case. Baldoni's lawyer is like, fuck it, we're going all in, put everything in the public. But they didn't turn around and then say, but this side can't put everything in the public. They said, we're putting everything in the public. We bet you won't because you won't like what it shows. Mention it all, bitches. Let's go. All right. Well, if you're going to say everybody's going to sling mud in the public, at least it's like, bring it on, everybody. This is rules for me and not for thee. And that pisses me off on a different level. All right. So they say Richins, a Camus mom and realtor, you guys, she's just a normal soccer mom. Do you get to count yourself as a realtor if your business is like a multi-million-dollar business, but that's all in the negative? You let me know. Charged with aggravated murder, attempted murder, and additional felonies. She also has a separate case with additional financial charges. If you have not gone and watched the video where we talk about the fraud case, we talk about Kouri Richins' bestie a bit, go watch. Bruised Violets 22 in the chat said they forgot author. How dare they? They also didn't mention how tall she was. You guys, how dare they not mention that she's an author? How dare they? It's fair. She's accused of attempting to poison her husband on Valentine's Day 2022. Oh, my chat has just stopped working on my end. That's not ideal. All right, it's back. Weird. She's accused of attempting to poison her husband on Valentine's Day in 2022 and then fatally poisoning him less than a month later. In the year between her husband's death and the charges being filed, she published a children's book about dealing with grief. There it is. Richins' attorney, Catherine, I'm sorry, it's not Kathy, it's Catherine Nestor. Oh, you guys.
Stop it. She also spoke to the media?
Are they pulling this from her filing or did she also speak to the media? Richins' attorney, Catherine Nestor, said one witness reached out to defense attorneys saying she was being harassed and asking the defense team if they could do anything, quote, to protect her from them. She said that the witness made it clear that O'Driscoll said she did not want prosecutors to prepare her for the testimony and asked them to send questions in writing. The response from O'Driscoll said, quote, you have received a subpoena to appear at the court as a witness. That's not for an interview, then. That's for trial. That's true. You have received a subpoena to appear in court as a witness. Fact. If you fail to do so, the judge will issue a warrant for your arrest. Fact. You will then have to sit in a holding cell until you are needed to testify. That's it. That's accurate. So make your life easier and answer our calls so we can prep you on what you will be asked. Otherwise, the next time I knock on your door, I'll have a warrant and a catch pole for the dog. I mean, you can't just leave the dog home alone. But also, I want to know if this witness, I really want to know if this witness said, yeah, come onto my property and see what happens. My dog likes pig chew treats. I really want to know. I really want to know. They're going to swab my dog's teeth and find nothing but pig. I'm just curious. Lauren in the chat. Lauren, this is a 10 out of fucking 10. This is a 10 out of 10. This is a 10 out of 10. Oh, my chat jumped. Lauren said, what? They just want to help walk the dog. I mean, Lauren, 10 out of 10. He just wants to walk.
Docket 214, but every law nerd on the internet calls it the walk the dog letter.
I'm real curious. I'm just real curious what preceded this. Also, witnesses don't have to answer the phone. They don't have to answer your calls. Make it easier on yourself and just answer our calls. We can tell you what you'll be asked. Yeah, they don't want to talk to you. So that's fine. He also did not provide a date she would need to come to the trial when asked, instead telling her to show up to the court every day of the trial, February 23rd through March 26th, because she had not replied. That's information the defense provided to the media. Also, that's how that works. It's an option. Here's what I'm hearing. I'm hearing that this witness was given an option. Hey, you can answer our calls, but if you don't, you've been subpoenaed. Generally, witnesses are subpoenaed for the first day of trial. And if you were subpoenaed for the first day of trial and you don't show up, then you issue the body attachments. And if you're uncooperative and you show up the first day, here's what the attorneys will do. Excuse me, Your Honor. Witness name is present in court on subpoena. Can you please order them back to court for tomorrow? Thank you. And then the court will look at witness and say, witness name. You are hereby ordered to appear in court tomorrow morning at this time. We will see you back here tomorrow. Failure to appear is a violation of the court's order and you may be held in contempt. Sanctions for contempt can include custody. And then at least they get the option to sleep at home for the night. You can sleep at home for the night, or we have cots. And then if the witness is not cooperative, they will order them back and trail them every single day of the trial. Is it petty? Is it annoying? Do people normally stop doing that after day one and say, yes, Your Honor, I will appear on Tuesday? Yeah. Yep. They sure do. See, as it turns out, adults do not like sitting in timeout in a hallway outside of court all day long. And if witnesses are uncooperative, and sometimes they are, then fine. Come back every single day and the judge will just keep ordering you back. It normally only takes one time that they get ordered back and then they change their mind. It sounds to me like options were given. Options. But I'm just not going to show up is never going to work. It's the problem. They will find a way to make it work and they know where you live. He did not provide a date she would need to come to trial, right? Because if you tell them we need you to testify on Wednesday and they don't show up on Wednesday, it fucks your whole day. You can't wait till the day you actually need them. You got to go sit them in the hallway on the hard bench. Go sit on the bench. A full naughty chair chat. It is. Go sit on the bench and wait. That's really inconvenient. Okay, well, you could make this easier. The defense says this is blatant witness intimidation. Am I missing something? I've had witnesses intimidated. I've had cases where witnesses have been killed. This is pissing me off. She said she met with lead prosecutor about the messages, and the response was that they did not think O'Driscoll acted improperly. I'm going to need the rest of the messages before I say how I feel about the catch poll, because I suspect that didn't come out of nowhere. So I have some more questions. We're kind of missing some context. The defense said that the prosecution denied a request to disclose other communications between O'Driscoll and witnesses in the trial. Did they just laugh on the phone, or did Bloodworth actually say, no, we're not going to do that? Because no, we're not required to do that. No, we're not going to do that is fair. But if they just laughed at you, that might be a little, I could see where that could be a little hurtful. It's not maybe ideal decorum. Emily, this sounds awfully personal. Yeah. Sometimes I can't help it. After the meeting, Nestor said in the motion that she had received communication from a second witness who said that they had been contacted by Travis Hopper, chief investigator for the Summit County Attorney's Office. The motion states that the witness asked Hopper to refer to their previous statement and was not interested in further discussion. In response, Hopper said, quote, "The immunity granted by the prosecution remains conditional upon continued cooperation. Declining to participate further may place that immunity at risk." That's actually a neutral, non-snarky statement. You guys. The immunity granted by the prosecution remains conditional upon continued cooperation. Declining to participate further may place that immunity at risk. And that's incredibly neutral. The witness responded that they had been told they did nothing wrong during an interview 2 years ago and that they had been cooperative. Okay, well then you don't need immunity. Why would you be mad about it? If the prosecution said your grant of immunity requires continued cooperation and you're like, I did nothing wrong, then call their bluff. Cap or no cap, whichever one's appropriate. Just say bet. I did nothing wrong. Fuck you. I imagine they probably don't want to roll those dice. When prosecutors are going after a murder prosecution, they're not going to play with you. Nestor argues in the motion that Utah code prohibits threats of harm against witnesses. These messages are less snarky than I would have anticipated. Okay. She said, if the communications are not criminal, they definitely violate the Victim and Witness Rights Act. You guys, when we start trial, bust out a piece of paper. Let's see if the defense violates the Victim and Witness Rights Act. Real curious. She also said these alleged threats are related to witness credibility, so any knowledge the prosecution has of similar threats must be disclosed to Richins' attorney. I can't imagine this is going to go well with the court. Deputy Summit County Attorney Margaret Olson said prosecutors will respond to the motion privately through the court, declining any public comments because the case is close to trial. Oh, chat. The prosecution's like, nah, I'm not responding to that. The court has asked us not to. And the defense is out here wilding out with text messages that are, well, not it. Just not at all it. Is there more than your immunity is based on continued cooperation? If you don't cooperate, that might be at risk. They didn't even text, it'll be real easy to talk to you when you're in jail. At least I'll know where to find you. I'm going to see if there is. A few of you in the chat said that KSL had some screenshots of these. I mean, the cherry-picked screenshots. I'm curious if there is more. So I'm just going to take a look at, oh, there's the motion to compel. Oh, KUTV has the exhibitees. Hey, KUTV. KUTV. Your bestie number one. Your bestie number one. How do you have these? They're sealed. On the court docket, they are... The fuck is happening? I'm pulling up the court docket. Give me a second, chat. Maybe I hallucinated last night when I was looking at this, because these exhibitees were sealed. We're going to the docket. What the fuck? Give me 1 second as I log in to pull up this docket. Utah is not the easiest to grab documents, but also not the most difficult. So, awesome. I knew that media had reported on them. I didn't think anyone had grabbed them. So this docket is pulling up. We're going to go to those exhibitees from KUTV. Miguelina, let me just give you I'm going to give you the link so we can put it in the description so that you guys can have it. It won't. Why won't it copy and paste? All right, I will do this in a minute because it just doesn't want to copy and paste. That's weird. Miguelina, I'll put it in today's doc so we can add it to the description after court. So law nerds, once I'm done streaming, I will make sure that that is in our description. So you guys can go look if you would like to. But for now, we're pulling up the exhibits. I didn't think we had these. I'm so excited. I'm so excited. All right, but first, I need to close the loop on whether or not, in fact, these were sealed or I just hallucinated. This is docket number 1419. We're going to go to the docket together. Did I pull the docket up this morning? No, I dealt with the docket last night. I've not pulled this up this morning. Let's go through this docket real quick. We're going to have to scroll a lot. Emily, it's not fair to... We're on docket number 166, Emily. You need to go to 1419. Give me a second as we scroll on this docket without making everybody freaking motion sick. Hold on. It's a lot of docket items. It's a fucking lot. It's a lot of docket items. All right. Tis said, are we looking at secrets? No, we're just looking at the doc. Well, maybe. We might be looking at secrets. Let's see. We were on docket 1419. All of these docket numbers, for those of you looking at the screen that say private, those are the ones that are sealed. It's private, and they have asterisks. It's very clear what is sealed on this docket. You can visually see it very well because the court denotes it so clearly. So every time you see private, that's sealed. And some of these are motions that are sealed. Some of them are other exhibits that are filed under seal. Some of them are motions to classify thing as private, and then the thing becomes private and it's sealed. I wasn't wrong. Motion 1419 filed motion to compel disclosure of communications with trial witnesses. Private filed Exhibit A, text between witness 1 and O'Driscoll. Private filed Exhibit B, text between witness 2 and Hopper. Private motion to classify, motion to seal defendant's motion to compel disclosure of communications with trial witnesses. So even the motion to compel, the sealing of them is under seal. They sealed the fucking motion to put it under seal. Now, as we look down on January 26th here, filed order to release HIPAA-protected records and order of protection. Those are allowed to be protected. Emily, what are all those? coroner stuff. These are coroner stuff. And releasing coroner information to all of the attorneys. So if Exhibit A and Exhibit B are sealed, how the fuck does KUTV have the full information? Gee, I wonder. Also, if the prosecution released sealed defense documents, where is the motion to sanction the prosecutors, get a new trial, remove the Summit County Prosecution Office, and delay the trial? Where's that motion? Because that would be fuckery. If the exhibits were sealed and the prosecution gave them to the media and their defense exhibits, it would be absolute fuckery. And the defense would lose their minds and they would be correct. Weird. And yet, here's Exhibit A. So, law nerds, let's take a peek at the sealed documents that are so needed to be sealed. They're so needed to be sealed that the defense gave them to the media. Sure. The name is redacted. Let's read the texts. We are looking at secrets. Chat, I'm making my own motion. I'm making my own motion for Code Red. This is actually fuckery. It's just absolute fuckery. Because what do you mean you seal the exhibits and then give them to the fucking media? If you don't want them sealed, don't seal it. But if you want them sealed, why are you turning over the actual court exhibit? It's just... Everyone who was on members only last night is like, oh, look, Emily continues to crash out at the media. Yes. Yes. What the fuck? I hate this. I hate it. I hate it. I hate it. I hate it. Motion granted for Code Red for any of you that are new to the channel. Code Red is flashy. If you are flash sensitive, it ends when the music ends. I do not like this at all. I don't. It's fuckery. And it's so dumb. Fucking seal it or don't seal it. Like, it's your choice. You don't get to have it both ways. Ugh. Okay. This is a text from no idea what date it is. Everything is redacted. I know you think you have nothing to do with this case, but here are the facts. You are a material witness in a murder case. You have received a subpoena to appear at the court as a witness. If you fail to do so, the judge will issue a warrant for your arrest. You will then have to sit in a holding cell until you are needed to testify. So make your life easier and answer our calls so we can prep you on what you will be asked. Otherwise, the next time I knock on your door, I'll have a warrant and a catch pole for the dog. I need to know the history behind that. I don't need to be prepared. I don't need to be prepped. Give me the time and date and I will appear. It's on your subpoena. Is there more an exact date, or do I need to be there February 23rd through March 26th? We could have discussed that if you ever replied, but since you don't want to, you can just plan on showing up every day at 8 a.m. And then it looks like it continues. I would like it over text message so that I have exactly what you say in writing. You are legally obligated to show up on the dates and times on your subpoena. This next one says Tuesday, December 30th at 11:28 a.m. At your request, I really need to set up a meeting with you to court prep you with the prosecutors. You are welcome to do it over Zoom, FaceTime, whatever. We just need to get you set up. Please respond. You can ask me whatever you'd like to ask me over text message. I do not want to be prepped. I do not want to be paid. Witnesses aren't paid. Sometimes you get a voucher for lunch. Whatever you'd like to speak to me about, you can send it through messages, not through county sheriffs. You guys are some blood-sucking, unfeeling people. So go ahead. What? So we're not the only ones that actually think Bloodworth might be a vampire. It's not just us. It's not just us. Very curious which witness this is. All of you are asking who's in blue. The person who is the witness would be in blue because the witness screenshotted this and gave them to the defense attorneys. You guys are some blood-sucking, unfeeling people. Well, you know, you get burned by a few witnesses, and then you go, all right, come to court, don't come to court. Whatever. Drive yourself, we drive you, we'll figure it out. You're a witness in a murder case. So, you know, come to court, don't come to court, whatever. So go ahead. What? I'm wondering if these messages precede the other messages, because the other messages just say today. I wonder if these are out of order. So go ahead. What? And it looks like a screenshot within a screenshot, or a screenshot within the text, maybe, because these are smaller. Our calls so we can prep you on what you will be asked. Otherwise, the next time I knock on your door, I'll have a warrant and a cash bowl for the dog. I don't need to be prepped. It's on your subpoena, more specific. So it looks like that's screenshotted. This says today at 1:54 p.m. I think these are out of... Could the defense like put these in date order? I mean, they're all... Yeah, look. On the screenshots, you guys, the top screenshots were screenshotted at 2:16. The other screenshots are screenshotted at 2:13. So even the screenshots aren't in order. Come on. And this one's fucking crooked. God damn it. And it seems like a duplicate. All right. So then, so go ahead, what? And then a screenshot and then crazy, period. Okay. Where are the rest of them? And how did this get copy and pasted into a document? Fucking sideways. Like, okay. I imagine there is more to this. Also, chat, we have now opened up Pandora's box of conversation. Chat, all of you, clocked immediately the 218 unread messages. Go look at your phone and just put in the chat how many you have. I'll tell you mine at the end of stream. Because I imagine some of you are going to be like, only 218, and some of you are going to be inbox 0. Oh, I'm sorry, not some of you. A lot of you are inbox 0. Mine's over 100. It seems that there is no variance between 0 and all. Chat, you're either like 0 or you're like hundreds. These are text messages, chat. We're talking about text messages. Mine are over 100. I'll tell you how many it is at the end of the stream. Or maybe I'll let you guess. Text messages. Yeah, there's no variance. It is either 0 or hundreds. You guys are the best. All right, chat. Should we go look at the other exhibit that is filed under seal and then leaked to the media by the defense? Why not? I appreciate KUTV for not just summarizing it. KUTV is like, no, let's ride. We'll just put the whole thing in our fucking article. And for anyone from the prosecution team who is watching this prepping, this article is from Monday, January 26, 2026 at 3:06 p.m. on KUTV.com, titled Attorneys for Kouri Richins Claim State Investigators Harassed, Intimidated Witnesses. And the dockets are embedded into the article, even though they're purportedly under seal. All right, let's go look at Sealed Exhibit B. And for those of you coming in on the code red, I made it code red because the defense was complaining about the prosecution. They filed exhibits A and B under seal. We looked at the docket. We saw that they were under seal. And then proceeded to give them to all the media outlets. Exhibit A, Exhibit B, private. I will leave open a teeny window that perhaps these were on the docket unsealed for 17 seconds. And in that 17 seconds, on a Sunday, the media somehow stumbled across them. However, KSL.com said that the screenshots were provided to them by the defense team. So I'm not super optimistic that this was a glitch on the record. Kobe said at 5 a.m. Exactly. You wouldn't know about it unless you had a heads up. Exhibit B, between witness 2 and Travis Hopper. Oh, okay. This does not have a date. The person is saved as Travis Detective. Hi, Travis. I've already given a statement and I'm not interested in talking about this any further. I understand your position and acknowledge that you have previously provided a statement. However, I want to clarify that the immunity granted by the prosecution remains conditional upon continued cooperation. Declining to participate further may place that immunity at risk. Accordingly, your cooperation is still required. Please give me a day and a time you can stop by the sheriff's office so I can discuss the issues at hand. Honestly, Travis, everything I have to say, I have already spoken and provided you with a document for everything you asked. I've been 100% forthright and cooperative, and I will continue to be cooperative. This interview happened nearly 2 years ago, and rather than take the time out of my busy day, what further questions do you have? I also want to add that when we met, I was told by everyone in the room that I had done nothing wrong. Even so, I will continue to be cooperative. Okay. Okay. I don't want to come in and talk to you guys anymore. I'll just show up at trial. Oh, okay. And I don't want to talk to you anymore. I'll be cooperative, but not if I have to talk to you. Okay. This is not going to count as witness intimidation in any stretch. The defense is allowed to ask these questions when the witness testifies. The witness is allowed to say, I don't want to talk to you before trial. The witness can say, I don't want to talk to you before trial. I'll come and talk to you at trial. Tell me what day you need me there. I'll be there. That's fair. Okay. Y'all, this is really trying to find tits on an ant. It really is. It really is. It's interesting to me that these witnesses went to the defense and said, defense, the detectives are being rude. Do something. All right. The court is not going to be overwhelmed with concern. I don't know why these exhibits were sealed by the court, and I don't know what preceded them. It seems that this text chain for Exhibit B probably preceded a, hey, we need a date, because this response, hey, Travis, I've already given a statement. I'm not interested in talking any further, seems fair. It's probably responsive to a, hey, we've been trying to schedule an interview. Where are you? Also, fine. Tell them to come to court. Fine, come to court on the day on your subpoena. Come sit in the hallway. So I have no idea who these witnesses are. I'm not going to speculate on that further. I guess when we get to court and we see the defense saying, did you speak to the prosecution before your testimony here today? Did you feel intimidated by the prosecution to having to come to court today? We'll find out. But we'll see. I am not overwhelmed with these text messages. And I can understand why when the defense reached out to the prosecution and was like, we're going to need all of the communications that everyone has ever had with any potential witness. And the prosecutor went, no, we're not doing that. I imagine that the court is also going to say, no. But if I was the prosecution, I would 100% be bringing to the court's attention that somehow these sealed exhibits found their way into the hands of the media. That would be very concerning to me. How are sealed exhibits getting out? The court has taken excessive, I think, lengths to keep things sealed. So if sealed exhibits are finding their way into the hands of the media that the defense has complained so much about, I find that deeply concerning. Gray Space said, would you have grave concerns? I do. I have grave concerns. I have grave concerns. I do. I have grave concerns how these got out. Okay. Sure. Exhibit A, sealed. Exhibit B, sealed. All right. I'm very glad that KUTV, who is now #1 bestie, put these in their article. and just embedded them on the website. Thanks, KUTV. That's eminently helpful. This article went up on Monday, January 26th. These were filed on Sunday, January 25th. Weird. Since we're on the docket, let's all explore together. I apologize for the scrolling. We're going to scroll a little bit quickly. Half of fucking everything is sealed. But we're going to see if there's anything new today. There is not yet. Emily, a bunch of stuff was filed on the 3rd. Yeah, it's all sealed. And then it's notice of the thing, which is like, hey, thing, sealed. Witness list, sealed. Motion to classify attachments to defendant's first amended Rule 16 disclosure, sealed. Motion to classify state's Fifth Amendment Rule 16 disclosure, sealed, sealed, sealed. All the electronic notifications are, hey, we did this thing. Sealed, sealed, sealed. Okay. So there is not a lot else to parse through that isn't sealed. But we do have the defense's new motion to change venue. Let me guess. Let me just guess. But Your Honor, there's been too much media. The witnesses know about the case, or not the witnesses, the witnesses should fucking know about the case. The jurors know about the case. They know about the case. Too much media. Too much media. Let's take a look. We're going to go back from Code Red to see what, if any, additional fuckery ensues. I appreciate attorneys doing their job. I find there is a way to do your job where you can lose your mind over the big things. You can bring up the things that are maybe not a huge deal and be like, yeah, we got to make the motion. But when everything becomes a big deal, nothing is a big deal. Nothing is a big deal. And making everything a big deal is just like, okay, here we go again. Everything's a big deal. All right. Everything's a big deal. And the hyperbole we've seen in some of the defense motions, everything becomes a, level 100 out of 10 fire. There's been a couple times when I'm looking at the cases in Massachusetts where I imagine the defense attorneys are just exhausted. And I'm looking at the cases being like, why aren't you screaming in court that you have not been given this discovery yet? Why aren't you screaming? And we haven't seen them screaming. Like, some of the things we've seen happen are really fucking bad. This isn't it. This isn't it. This isn't it. Beeline said, this level of hyperbole is unproductive. 100%. All right. Let's see. A couple of you asked if there was a state's response to this. I didn't see a state's response to this on the docket at all. What was that, 125? Let's just go look together. We have the docket pulled up. Let's just go see. We'll double check, but I didn't see a state's response to this. I imagine the state's response to this is like, and I rolled my eyes so hard I got mascara on my eyelid. Ugh, fantastic. I imagine the state's response is, really? Let's go take a look. What docket were we just on? Were we on 1419? I think that's where we were. There's so many fucking docketed items. I think we were on 1419. Yeah, 1419 is where we were. So hold on. Let's get to 1419. We have Motion to compel disclosure of communications. So we are looking for the state's opposition to the defense motion to compel disclosure. The objection to motion to seal, by the way, is a defense objection to something else. It's not a state's objection regarding this. Notice of return of SDT. State's fourth amended Rule 16. That's not it. Notice to submit for decision, motion to reconsider excited utterances. This is about I'm waiting for the court to rule, but this is about the hearsay exceptions. And the notice to submit for decision is telling the court, hey, you have everything you need to have. Motion to classify Hayden Jeff's use immunity letter. Hey, Hayden, why you got immunity? You texting? Who you been texting? Have you been texting with Travis Hopper? Motion to classify O'Driscoll text exchange. So there is a response. Memorandum states opposition to motion to compel disclosure of communications with trial witnesses. It's fucking sealed. It's fucking sealed. So let me get this straight. The defense files their motion. The defense seals their exhibits and then gives their exhibits to the media. The prosecution, because the defense sealed them, responds with them being sealed, because once the defense has sealed them, it is not for the prosecution to then file the response unsealed. That would be inappropriate. So the prosecution filed the entire thing sealed. They also filed a transcript of a recorded interview under seal. And we're never going to see, until the docket is unsealed, we're never going to see these exchanges. I don't know who this witness is, chat. They have used witness numbers, names. They have referenced people. I don't know who this witness is. We're going to have to wait and see because the exhibit lists are sealed. So I don't know. I'm not going to speculate because it's more harmful to have that information lodged in my brain incorrectly. I'm going to wait. Sealed, 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 sealed. Sealed. Motion to classify state's motion eliminate sealed. That's a different motion. 1, 2, 3, 4 sealed records. 5. Okay. Views through a lens asked what's appropriate about this. I'm going to answer this question on multiple levels because I think there's multiple levels to this question. First, I do not agree that everything should be sealed. I think too much has been sealed in this case. I have issues with too much being sealed in this case. However, I am not the judge. It is not my case. It is not my business. And it will come to light after trial. These things will eventually get unsealed. Would it be helpful for us to have them unsealed? Yes. Does it impact the transparency of the court when we are weeks away from trial and these will be unsealed later? I think there's room to make an argument. I don't think it's the most compelling argument because we have seen a lot in this case and we are very close to trial and very close to jury selection. And if the media ramps up, which it will, closer to jury selection, we will see media on this case start to take off. And then people, the name on everybody's lips is going to be, well, probably Roxy. Oh, how pissed is Kouri Richins sitting in custody being like, what do you mean? What do you mean there's Secret Lives of Mormon Wives and that there's a mom talk? What do you mean she's performing on Broadway? Ugh. Why aren't they talking about me? Just my speculation. But this case is going to start to pick up traction as it gets closer to going to trial. That was a really deep cut back to the fact that one of the women from Secret Lives of Mormon Wives, TikTok Mom Talk, is now performing on Broadway as Roxy Hart. I know. Mm-hmm. So when we're talking about what's appropriate about this, I think too much is sealed. Not my call to make. I would prefer to see less being sealed. I will quibble with it later. It will get unsealed. We can wait. I hate trying to be patient, but we can wait. But what's appropriate when the defense seals an exhibit is that the prosecution's response, if it references the content of that exhibit that's sealed, is also under seal. Because if the defense files something under seal, and then the state's response is not under seal and puts the information that is sealed out there in their response, then that would be inappropriate. It would be getting around the sealing and it could damage somebody's case. And it's not for the prosecution to determine the appropriateness of what the defense sealed without making a motion to unseal. So if the prosecution didn't want to seal their reply or their opposition and their exhibits, they could make a motion to the court asking that it be unsealed. And my argument would probably be this should be unsealed because the defense gave it to all the media. So it's already fucking out there. So what's the point of sealing it? If the point of sealing it is to keep the jury from information that they might not hear at trial, because these are things that very well might not come in at trial. And that's one of the points of sealing information, is that this might not come in at trial. So you don't want to taint the jury pool with information that they might not hear at trial. But could you see the defense wanting to taint the jury pool with information that they say characterizes the investigators as being intimidating bullies that are harassing witnesses and threatening their dogs? Because then if you're sitting on the jury pool, you're like, guys, is that the guy who threatened the dog? Fuck that guy. Fuck that guy. Right. They don't want the jury pool tainted unless they're the ones tainting the jury pool. And that is fuckery. Either it's all out there or it's not. Northwest said the state's response is out in the media. I don't know if that's a question or a statement. Stina G said actually sealed, or did the defense leak it somewhere? Both. It's actually sealed and the defense gave the media the exhibits. How do we know that? Because the media said the defense gave them the exhibits. What context supports that? The fact that the defense isn't in court losing their fucking minds that the prosecution leaked sealed exhibits. If the prosecution leaked sealed exhibits, how fast would the defense go to court screaming that this is improper, that it has tainted the jury pool, that the prosecution should be removed from the case, that the trial has to be continued, that the venue has to be changed? Like, how fast can you type before you go to court? How fast can you type? And I would agree with them. If the prosecution was leaking defense sealed exhibits, I would agree. Absolute fuckery. I don't know if you have to change the prosecution team on the case, but I would be furious. The prosecution should be mad about this, but they're probably just like, par for the course, everybody. It is what it is. But it's the headlines that can taint the jury pool. A lot of people, especially if you are living in Utah, I would imagine, you might start seeing these headlines coming across your social media. And what are the headlines here with this particular story? Let's see. Kouri Richins' defense claims witness intimidation. Kouri Richins' defense says state investigators harassed and intimidated witness. Kouri Richins claims witness intimidation by Utah investigators. So if you just see the headline, that sounds bad. Ew. Why would they do that? Gross. Why would they be threatening witnesses? We hate that. Don't do that. And then if you go a little deeper into the headlines, you're like, uh-huh. So where are we at? Right. Okay, let me see if I can find I don't see the prosecution's response. But I will take a quick look, and if I can't find it, then Kouri Richins accuses prosecution of blatant witness intimidation. There's another headline. Oh, this one, though, is a little spicier. Utah children's author they called her an author. Utah children's author Kouri Richins says state threatened witnesses ahead of trial in husband's poisoning. I mean, that does at least talk about her a little bit, I guess. So I don't see the state's response anywhere. A couple of you are just coming in saying, why does my app say code red? We were in code red. We were full code red for fuckery. We were a full proper what the fuck level of fuckery code red. All right. I don't see the state's response. If I find it, we'll bring it up on stream tomorrow. So for now, we are moving on to the defense's new motion for change of venue. They filed the text message motion on January 25th, Sunday. Somehow the media all has it on Monday. They filed the motion to reconsider change of venue on January 30th. I have not read this yet, chat, but I'm guessing that this is going to be, but Your Honor, we have all these questionnaires back, and all of these jurors know about the case. We have to change venue. She can't get a fair trial here, right? I imagine that's what we're going to see from this motion, but let's go take a look because one never knows until we look at it. All right. Now we get to do a proper swoop. We've changed topics properly. Do a swoop. Then I'm going to have to turn on my heater because now it's cold in my office. We love this time of year. The hair is staticky. The air is dry. It's cold. It's not cold. It's cold. All right. Docket number, not next in order. I meant to look it up. Emily, what docket number are we on? Docket number 1465. No, this is the opposition. Emily, you pulled up the wrong one. Shocking. That one's going to wait. This is the right one. Let's do this. I hate these summaries. If anyone can tell me how to turn off the document summaries in Google Drive, I'd be immensely grateful. I have not been able to figure it out. All right. Defense motion to reconsider change of venue. Kouri Richins, through her lawyers, asked this court to reconsider the defendant's motion to change venue. This is the first time the trial got put over for an extended period of time because they took this all the way up on appeal. And the Court of Appeals said, no. I also think the timing is appropriate. It's very hard to determine if you really can't have a fair trial in a particular venue until you start hearing from the jurors. And if every single juror comes in and is like, oh, I know about her, I think she's guilty, then you have a problem. And you might have a venue, you might have a location that has been so tainted against the defendant that they cannot get a fair trial. However, Just because someone has heard of the case doesn't mean they can't be fair. Somebody could be like, oh yeah, I heard about that, huh? And not everyone in a jurisdiction is going to have heard of a case. Media has become much more personalized. And there are going to be some members of the jury pool who have curated their feeds that they don't see any of this shit. They might be able to tell you everything that's happening on reality TV. They might be able to tell you everything that's happening in, like, I don't know, deep sea exploration in the world of the octopus, because all they follow is Octonation, which, fair. This might not even come across their feed. And if they don't turn on local news and they watch only YouTube, then they might have no idea this case even exists. It's not as if you turn on one channel in the evening and that's the only thing going. It's so decentralized now, as we can tell by the media continuing to grasp at relevancy. Emily, you're real salty today. I am. Not all media, just some. All right. Kouri Richins, through her attorneys, want to change venue. Remember, they wanted to take the case from Summit County to Salt Lake County. They wanted a bigger county, big, huge, more people, big, huge. That's what they wanted. The court said no. They took it up on appeal. The Court of Appeals said no. Maybe the defense will summarize it. Optimism. In the defendant's original motion to change venue, the defense argued that there was a reasonable likelihood that a fair trial cannot take place in Summit County, which is the standard set forth in State v. James. The, quote, reasonable likelihood standard stems from the number of cases cited in the defendant's original motion, including Maine, when the dyslexia and ADHD just get together and we can't read. Maine v. Superior Court, which noted that, quote, the phrase reasonable likelihood denotes a lesser standard of proof than, quote, more probable than not. So when we're looking at the lower standard of proof, they're like, the bar's low on this one. Further, when the issue is raised before trial, any doubt as to the necessity of removal to another county should be resolved in favor of a venue change. We may have to look at these arguments in the Charlie Adelson case tomorrow. I'll put up a poll. Later today and see if we want to take a look, because the Adelson appeal is making the same arguments, and we might need to go take a look at that. They go on to say, now that the court has responses to the jury questionnaire, it's obvious that Emily can't use her document. It's obvious that Ms. Richins does not have a reasonable likelihood of a fair trial in Summit County. What would that mean if the court were to grant this? What would that mean? It would mean that the trial would have to be moved to a new court. And it would mean that the trial would be continued at a minimum, probably 4 or 5 months, maybe more. It would push this trial out. Could be up to a year. So the defense is saying it's obvious that Kouri Richins cannot get a fair case. Can we just, yes, thank you, my document, for playing nicely. The survey conducted by the defense last year determined that 79.8% of Summit County residents recognized the case before the court. So they've heard of it. And of those, 49.1 had been following the case either very or somewhat closely. So of the people that had heard of the case, less than half of the people that had heard of the case had been following it closely. The actual numbers that are now before the court are higher. Of the 1,723 questionnaires that were returned, 1,472, or approximately 85.3%, recognized the case. Okay? Of those that recognized the case, 884, or approximately 60%, followed the case either somewhat or very closely. During oral argument at the April 17th, 2025 hearing, the court stated as follows. The court, I guess what I'm saying is, why wouldn't we focus on the 200 that don't recognize the case to start with? The court said to the defense, I'm willing to consider throwing out every juror who had ever heard of the case, which actually I think the state could have an argument against, saying actually that's unfair to take a jury pool that is informed, has heard of the case, and throw them all out. Shouldn't we just take out the people who had followed the case closely? And the court was like, no, I'm willing to. I'm willing to throw out every juror who said they'd ever heard of the case. Which is further than I've seen a lot of judges go. A lot of judges are like, okay, well, if you've heard of the case, that doesn't mean you've made up your mind. So the court was willing to narrow it down to people who had never heard of the case. It's a generous offer. Miss Lewis, the other defense attorney, not Nestor, Lewis said, so we're going to strike every single person who said they've heard of the case. The court said, well, that's your decision, not mine. We covered this hearing together. April 17th, 2025 hearing transcript. The defense agrees that it is most appropriate to strike all jurors who have heard of the case, which leaves 251 potential jurors. Okay. However, most of these jurors answered other questions in a way that would immediately strike them for cause. But Your Honor, of those 250, we hate all of them. When those jurors are removed, we are left with approximately 72 potential jurors. I mean, that's more than what, 8? They get 8 on this case plus alternates. Even if they doubled it, that's more than 16. And no, chat, they do not get 12 in this case. We went over those hearings way earlier in this case. They get 8 for this case to decide it. Utah only does 12 in capital cases. This is not being pursued that way, so they only get 8. They go on to say, with a jury pool of less than 100, it would be nearly impossible for Kouri Richins. Oh, wait, there was a footnote. I'm sorry. Footnote voice. It's been a minute since we've had a footnote. Footnote. In coming to the number 72, the defense removed jurors who indicated that they had hearing problems, were taking medication, or had impairments that left them unable to serve. You fucking joking me? First of all, there are ways to handle people who have some hearing loss. You don't just kick people because they have some hearing loss. You accommodate them. Also, you kick everyone who's taking some medication? Are you fucking joking me? Excuse me, Your Honor. We kicked every single juror who took medication. No. In coming to the number 72, the defense removed jurors who indicated that they had hearing problems, were taking medication, or had impairments that left them unable to serve. Further, jurors who indicated that they could not follow the law, who could not be impartial, or who were not able for the trial dates, new witnesses, had beliefs against resolving disputes in court, or indicated no to answer question 93 were also removed. That's wild. Excuse me, Your Honor. We just removed everyone else. Thanks. That's a choice. Okay. With a jury pool of less than 100 jurors, it would be nearly impossible for Miss Richins to receive a fair trial by a jury of her peers. Oh, I'm sorry, chat. We've redefined a jury of her peers. And since Kouri Richins is better than the rest of us, there aren't many of those. So it's, you guys, you don't understand.
Like, I'm a super successful author. I wrote a very detailed novel. I am a creative genius. And you just don't understand. Just a normal mom. But I deserve a jury of my peers. And a lot of you just don't make the cut. Yeah. Fair. I need a fair trial. Obviously.
You guys, we're just not her peers. Come on. This is not what this is for. This is for people who come in and are like, I have read every document. I've watched every hearing. I know everything about this case. Bloodworth, how's it going, my guy? Judge M, in love with you. Kathy Nestor, don't insult us that nobody lets a breakfast sandwich sit for more than an hour before they eat us. Come on, girl. We've all done it. Stop, I'm offended. Those are the jurors that they don't want. Fine. Jurors who know everything about this case and are like, there's no way I can be fair. I know too much. I've seen too much. Fair. But to kick every juror who has indicated that, yeah, in a courtroom, it might be harder to hear, so I need the witnesses to use a microphone. You're going to encompass people who are trying to be forthright with the court, who are trying to be honest, and who are like, I don't know, sometimes I can't hear when my kid's talking to me, so do I answer that question, yes or no? You're going to encompass so many people who are trying to be forthcoming with the court. Chat, if you had a question from a court on a jury questionnaire, and you wanted to serve on jury duty, start with that premise, work with me, and you wanted to serve on jury duty, would you do everything you can to make sure that if you thought the question maybe could be a yes, wouldn't you just say yes? Because you don't want to say no and then be like, oh shit, should I have said yes? Most people are going to be like, okay, well, it's a maybe, so it's a yes. Because I want to be transparent. Because that's my duty. And I don't want to mess it up. Like, I don't want to fuck it up because then I'll get in trouble. So if it's a maybe, it's a yes. And then to try to kick all of those people is fucking wild. So, RN Becky in the chat said, don't answer the question until you get to the courthouse. Unfortunately, it's not an option in this case. These were mailed jury questionnaires, and then they are taking the group from the questionnaires and then calling them in for individual voir dire. So they are narrowing down the veneer. Judge M's going to call it a veneer. Judge M might be correct. I'm always going to pronounce it veneer. We'll just have to agree to disagree on that. Even if I'm wrong, that's how I pronounce it. So they're trying to narrow it down from the questionnaires to get to the veneer, and then pick jurors from there. And if a juror fills this out and is like, I have tickets for vacation already planned, that person's not even going to get called in and be questioned. That questionnaire is going to come out of the stack. They'll get called again for jury duty later. So there will be some jurors. If there's a juror that's like, if I don't see Docket 214 admitted into this case right now, I can't even with any of you, that juror is probably going to get yeeted. They know too much about the case. So they're narrowing down the veneer based on the mailed questionnaires. The fact that they had 1,700 responses, they had 1,700 responses to jury questionnaires. It's so many people. So with Emily crashed out over Kouri Richins' peers. My bad. I did. The hyperbole is a lot. With a jury pool of less than 100 jurors, it would be nearly impossible for Ms. Richins to receive a fair trial by a jury of her peers. Further, as testified to by Dr. Edelman at the hearing, yes, chat, same as the Koberger case. Further, as testified to by Dr. Edelman at the hearing on the motion to change venue, once potential jurors are presented more facts, there is a high likelihood that several of them will realize that they are in fact familiar with the case. Dr. Edelman used the example of the I can't remember how to pronounce that case, Feet murder in Texas when discussing how memory works. He testified that when potential jurors were asked to say everything they knew about a case, they would say a number of things and claimed that was all they knew. However, when presented certain facts, did you hear that this and that? Then they would go, oh yeah, I did know that. This motion continued with several questions, each question triggering additional memories. And then they cite the transcript. This is relevant to the small number of potential jurors left in this case, because those jurors are questioned and potentially reminded of additional facts. The walk the dog letter did make an appearance. Oh my God. Oh my God. This is relevant to the small number of potential jurors left in the case because the jurors are questioned and potentially reminded of additional facts such as the walk the dog letter. It's likely they may realize that they are both familiar with the case and have an opinion about Miss Richins. But Your Honor, once they come in here and see her face, they're going to be like, oh, her, I know her. My bad. Those jurors will need to be removed for cause, leaving us with an even smaller pool of potentially qualified jurors. Although there is no magic number as to how small a jury pool or venire can be under Utah law, the jury pool must represent a fair cross-section of the community. The smaller the pool, the less likely this to happen. Further, to seat a jury of 8 with 4 alternates. Oh, good. They stated the amount of alternates. The court must qualify 43 jurors. When starting with a pool of approximately 72, the chances that this can happen are little to none. The reason they say they need at least 43 is because of the peremptories each side has. As argued previously, the standard for a change of venue is not simply a numbers game. The question is not, are there 8 people in Summit County who are qualified to serve as jurors? If this were the standard, there would never be a change of venue in any case. The question is there a reasonable likelihood that Ms. Richins can get a fair trial in Summit County? With the juror questionnaires in hand, it is clearer than ever that the answer to that question is no. Well, I mean, we've got a lot more people in the chat than they had answer questions, but chat is we are excluded. I mean, most of you honestly are excluded because you don't live in Summit County. The handful of you that are in Summit County, you're also excluded because you're here. Sorry, law nerds. No jury duty on this case for you. You'll be excellent jurors on another case. So as argued previously, the standard is high, just like the tide. The answer is no. But Your Honor, they know about the case. For the reasons stated herein and the reasons set forth in defendant's original motion to change venue, the defendant respectfully requests that the venue in this matter be changed from Summit County, Utah to Salt Lake County, Utah. They really just want to go to Salt Lake. But Your Honor, those people in Salt Lake, they'll be like way more fair and stuff. Let's see what the state has to say in response, because I imagine what the state's going to say is, excuse me, there are plenty. I saw a tail. Now you're behind my chair and I can't see. Hi, Fred. Scrambled Eggs said, Emily, are there legal protections against striking a juror due to disability like hearing? It's really going to vary by jurisdiction. What the defense is always going to argue is that Kouri Richins has the right to a fair trial. And if a juror cannot hear all of the evidence and the court cannot accommodate assisted listening or other accommodations, then it impedes her right to a fair trial. So no, the rights of the defendant are what the court is most focused on protecting. There are some jurisdictions that have age limits and are like, after this age, you cannot serve on jury duty. So it really depends on the jurisdiction and the attorneys. So not the just asked, would I be kicked if I have a service dog? You shouldn't be, because you have a service dog. But also it's going to depend on if the court can accommodate that. And if one of the attorneys is allergic to dogs, it might become a different kind of issue. So it depends on the court and the case. But no, some courts would absolutely be able to accommodate a service dog. They would probably ask you in voir dire what your service dog is for. If your service dog, is going to be a great juror, because obviously we're going to go with what the dog says. And if it is something that could potentially disrupt the trial, because what they want to make sure is that you are going to be able to serve as a juror for the entire span of the trial. And if there is a concern that that might not happen, then they might take it case by case. Like, hey, a 3-day trial, you've got me. A 5-week trial, probably not going to work. So it just depends, truly. Hi, Fred. I think hopefully that helps. Just really depends. All right, Fred, we're going to see what the state has to say. You heard me when I said I got all the cat hair off the microphone then? You heard me? You heard me and said that I got all the cat hair? Thanks. I appreciate that you've replaced it. Thank you. So, for the defense, zealous advocacy is going to be the focus. Okay, say hi to the law nerds, big boy. You can go watch the birds that way, all right? It has stopped raining. The birds are back. I know. Cat glitter. Thank you. Thank you, Fred. Thanks, buddy. So the defense's zealous advocacy for their client is going to be their primary focus. And if that means they are going to be like, look, Your Honor, their goal, remember, this is advocacy. The defense's goal is and has always been, get this case to Salt Lake City. And if they can argue that goal by saying, we've got to strike all of these people for all of these reasons, that's what they're going to do. That is their job. That's what they're going to do. I don't like it, but that's what they're going to do. And this is made for their client, not for the broader internet to be like, what do you mean you're striking everyone who's on medication? This is insane. This is what goes on in courts. This is a realistic look at what happens in trials. They have wanted to move this case to Salt Lake County since the beginning of the case. So they're going to try it again. Hopefully that helps. It doesn't feel any less ick, but it is the reality. Let's see what the state has to say. State's memorandum in opposition to motion to reconsider venue. And I think there's probably a lot of areas in law where we can look at it and be like, is this someone doing their job? Are they looking out for the best interest of their defendant, their client, even if we disagree with how they're doing it? And can they do that? All right. This is docket number 471. This was just filed on February 1st. The state requests that the court deny defendant's motion to reconsider change of venue. The questionnaire responses strongly suggest that a fair and impartial jury can be impaneled in Summit County. Indeed, the questionnaire responses largely track the data that the court relied on in deciding change of venue. The motion's misrepresentation of defense counsel's discussion with the court during the change of venue hearing does not create a new legal standard or truly shrink the number of viable jurors Okay. Okay. Excuse me, Your Honor. They're doing the thing again. Your Honor, they're doing the... Your Honor. They're doing the thing again. The motion's misrepresentations of defense counsel's discussions with the court during the change of venue hearing does not create a new legal standard. Excuse me, Your Honor. Make them stop. Statement of facts. Statement of real facts. Statements of the in fact facts. The court's careful reasoning. Excuse me, Your Honor, you're our bestie number one. Your Honor, you're tall. Definitely, actually, the court is tall. I'm not even being funny. Your Honor, you're taller than Brendan Banfield for sure. Very wise, very fair. Beard's a sleigh. We love you, Queen. The court's careful reasoning denying the defendant's first motion to change venue is set forth in the record using the data and testimony from the defendant's own expert. Excuse me, Your Honor. You're correct. Look at how correct you were. In fact, you were so correct. Just keep being right. Hard to win. Just keep winning. Thanks, Your Honor. The court found that 20% of Summit County residents had not read, seen, or heard anything about this case. Among the 80% of Summit County residents predicted, remember, the sample size in this was incredibly small. Among the 80% of Summit County residents predicted to have read, seen, or heard something about this case, 73% have no connection to Eric Richins' family. 31% have not formed an opinion regarding defendant's guilt. Of the 69% that believe defendant to be guilty, 50% believe that defendant would not have a difficult time convincing them that she is not guilty. Let's talk real quick about that. The way that the survey frames that question is then used for the argument, see, Your Honor, they say the defense would have to prove it to them. The defense doesn't have to prove anything. These jurors need the defense to prove it to them, and that's not the standard. But that's the way that the question is phrased. The questioning is, would the defendant be able to prove to you? It's in the way that the question is written. Ask better questions, get better answers. That question gives them something to fight with. It gives them room to say, see, Your Honor, they need us to convince them. We don't have the burden. So 50% believe the defendant would not have a difficult time convincing them she is not guilty, and 15% have followed this case, quote, not at all. Dr. Edelman's survey predicts that if 100 Summit County jurors walk into a room, 44 of them would not have prejudged defendant's guilt. Because the whole question is, are they prejudiced against the defense? That's where my brain went. 44 of them would not have prejudged defendant's guilt, and it would not be difficult to convince 28 of the rest that she is not guilty. These ratios do not support finding a reasonable likelihood that a fair and impartial trial cannot be had in Summit County. On June 6th, the Utah Supreme Court, funny about that. On June 6th, the Utah Supreme Court denied the defendant's interlocutory petition for permission to appeal the ruling. Of the 1,723 juror questionnaire responses, 830 potential jurors report that they had never heard of the case. If you can't find 8 people out of 830. potential jurors report that they have never heard of this case and or followed the case, quote, not at all. 681 have followed this case only, quote, somewhat closely. So I'm sorry. Are you telling me just to make sure I don't like lawyer math or like girl math with like, oh no, it's not that expensive. Like just 830 haven't heard of the case or followed it not at all. And then an additional 681 have followed the case only somewhat closely. So out of 1,723 jurors, 1,511 of them are like, meh. Oh, okay. Argument. The motion's premise is inconsistent with the jury selection rule and the court's decision with defense counsel or discussion with defense counsel during the change of venue hearing. If a potential juror can and will act fairly and impartially, they must be passed for cause. Contrary to the motion, the court never stated in its discussion with defense counsel that it is most appropriate to strike all jurors who have heard of the case. No, the judge asked it as a question, is my memory. The judge was like, is this just what we do then? If this is a problem, do we just strike everybody that has ever heard of the case? The court's like, is that what we're going to do? The court did have that discussion. The court didn't say, I'm going to, but the court asked, could we do this? Right. The motion then uses this misrepresentation to cast 251 as the number of viable jurors. Not true. I disagree with the prosecution a little bit in that because I think the defense also said, hey, but we're also kicking off everybody who's ever taken medication. But the court did have that conversation of should we just yeet everybody that says they've heard about it? Is that what we should consider? And I also understand where the court wants to have that conversation, because if a juror is like, yeah, I've heard of the case, but I don't really have a thought about it, in the back of their mind, does their beyond a reasonable doubt become a higher burden than someone who's never heard of the case, never heard of the defendant? Is it harder to overcome the burden? Or is it like my beyond a reasonable doubt gets reduced? Like, are you already almost too beyond a reasonable doubt before you hear any of the evidence? And there is consideration and there's room to consider that people want to go to court and say, Your Honor, yeah, absolutely, I can be fair. But then are they also subconsciously holding the prosecution to a lower standard because they already have an opinion formed? I don't know. Where is the power of suggestion in that? If we start talking about, Emily, we're going to talk about the power. Like if we start talking about needing a Dr. Pepper from Wendy's, which frequently, yes, does it sit in your mind going, I mean, I kind of do though. And is it unfair to compare those two things to trial? Because what I've found is jurors actually work pretty hard to keep an open mind and want to keep an open mind. Most people, not all, most people, when they sit on jury duty, take it incredibly seriously. And they want to feel good about a very, very heavy decision. Convicting someone of murder is a weighty decision. And jurors want to discuss with each other, did we consider everything? Are we being fair? What about this? What about that? So where are the boundaries of that? And that's why you have jurors deliberate. So I'm not surprised that the prosecution is like, Your Honor, the defense is wrong. It's 1,500 people. The questionnaire responses suggest a fair and impartial jury can be impaneled in Summit County. Oh my God. I have just so much cat fuzz. 48% of the questionnaire responses have never heard of this case or followed it, not at all. Have you followed this case? No. None. 40% have followed the case only, quote, somewhat closely. The questionnaire language does not precisely mirror the defense's survey language, but the findings that the court drew from the survey data in denying the change of venue hold up. First, try in-state versus Whittiston. The Utah Supreme Court reviewed a high-profile murder conviction. Quote, during jury selection, the defendant moved 3 times to change venue based on allegations of gossip. No. The rumors. Gossip. I mean, it is Utah. Based on allegations of gossip and wide discussion in the community about the case. You know what else we didn't get in the Banfield case? We didn't get to hear what the IRS gossip was. We don't know what did the voice say on the 911 call? And we never got to hear what the gossip was. Because T. Patrick was like, I mean, there was gossip and we also don't know what kind of cookies they were. We do have some lingering questions. Those questions don't ultimately weigh on guilt or innocence, but we do still have questions. So apparently the defense in the Whittiston case wanted to change venue based on gossip and discussions in the community about the case. The trial judge denied the motions, stating that it would deal with the issue later if it came up and could not impanel an impartial jury. In affirming, the Utah Supreme Court looked only to, quote, whether defendant was ultimately tried by a fair and impartial jury, which is what matters. The fact that some jurors have heard about the case is not what matters. What matters is finding jurors that can be fair. Conclusion. The court should deny the motion because a fair and impartial jury can be found in Summit County. Look, if you can't find a fucking jury of 8 plus 4 alternates out of 1,500 people, you got bigger problems. All right. Why does the defense want so badly to move to Salt Lake County? One, I think it's probably close enough that it wouldn't be horribly inconvenient to the defense and their witnesses to move it to Salt Lake County. And 2, there's more people. And I imagine their client feels some kind of way, because we saw it in their other motion. The client feels some kind of way about being in Summit County. And it would push the trial out like another year. It would push the trial out another year. So the court was back in session in the Richins case on Monday for the beginning of narrowing down the jury questionnaires. We did not hear that. What does that process look like? It looks like numbering all the questionnaires, going through the questionnaires, and then saying, okay, questionnaire number 1, or defense, which questionnaires do you suggest we take out for cause? And they're going to take that stack of 1,700 questionnaires. They're going to narrow it down to a veneer or a pool, and then they're going to send out notifications to groups of potential jurors to start coming in for individual voir dire starting on Monday or Tuesday. I keep seeing the difference between Monday and Tuesday. Either way, it doesn't matter. The court has given them 2 weeks for jury selection. Opening statements are set to start on February 23rd, because of course. Emily, what happens if they pick a jury sooner? It's unlikely to me that Judge M would bounce opening statements forward a day. I just don't think that or forward a week. I don't think that he would. Jury selection will not be streamed, televised, no audio only, nothing. So in everything that we looked at today, they were back in court on Monday, and we have no additional filings on the docket. But we do have reports that the court ruled on this on Monday, even though it's nowhere on the docket. Which means that there must have been somebody in court listening in on the hearing on Monday. So let's go to, let's see, Salt Lake Tribune. That seems to be appropriate. Since everybody wants to be in Salt Lake so badly, let's go to the Salt Lake Tribune and see what their reporting is on the court's ruling. Because even though it's not on the docket, apparently the court ruled. Because the court does kind of rule. That's what we were trying to do. Judge denies second request to move trial away from Summit County. This is just fighting. There we go. That's going to be easier. The defense had argued that results from a jury survey showed a fair murder trial was impossible. I appreciate the picture they picked of Kouri Richins looking like she is pointing at the judge. It's kind of funny. Attorneys for the Camas mother accused of killing her husband have long argued that the close-knit Summit County could not guarantee Kouri Richins a fair trial. They doubled down on that notion. My brain thought that needed to be motion, and then the sentence didn't work and I got confused. They doubled down on that notion January 30th, arguing in court papers that the trial should happen in Salt Lake County, because 85% of the 1,700 Summit County residents queried said they knew about the case. It was the second time that the attorneys have asked for a change of venue. The judge denied the request February 2nd. Summit County prosecutors throughout the questionnaire responses thought the questionnaire responses were consistent with the previous community surveys. Richins is charged with murder. Read the full story at what's KPCW? Oh, all right. Hello, KPCW. Judge denies second request to move Richins' trial away from Summit County. Well, that's a nice neutral headline. We appreciate that. That's just the facts. Hey-oh, look at that. It is possible. Love it. Just the same photo. Same photo. Same exact story scraped for a different outlet. Let's see if there's anything new in this. Monday, defense attorneys and Summit County prosecutors met with the judge to whittle down the pool of prospective jurors based on their questionnaire responses. Those remaining will be called for in-person questioning starting February 11th. The original scheduling order has February 10th. The court might have changed it. Utah requires 8 jurors and 4 alternates. In court papers, the Summit County Attorney's Office said it only makes sense to think twice about moving the trial if, after verbal questioning, the parties can't find 12 suitable candidates. I think that's fair. Jury selection is expected to conclude February 18th. Also, at the February 2nd hearing, Judge M extended the length of the trial by 2 days, March 13th and 20th. It's still scheduled to begin February 23rd and end March 26th. Your Honor, did you just go put Fridays on the docket? Or were those dates that you had already taken? Your Honor.
Excuse me, Your Honor. You said no Fridays. You said no Fridays. You said no Fridays. Why are you adding Fridays? We love a 4-day work week. Balance, Your Honor. Balance.
He's worried they're not going to get done. He's worried they're not going to get done. Of course he's worried that they're not going to get done. Well, at least it's only 2. We're still going to be off Friday, March 6th and Friday, hopefully February 22nd or 27th. Judge M's like, shit, these lawyers are not going to get it done. These lawyers are not going to get it done. No. All right, well, I appreciate that the court added 2 more days. He's worried, I'm sure, that they will not get it done in the time. The attorneys have been working together well, but there has been a lot of work that is needed. And so no matter how smoothly the prosecution goes through this case, there are still going to be things that take time. There are still going to be things that just need more time. Lona said, to get what done? Oh, the trial. He's worried they're not going to get it done in the time that they've told the jury. And instead of extending the trial beyond the date they're telling the jurors, then he's just adding in the Fridays to try to make sure they can get done by the date they told the jury. They told the jury in those questionnaires that they mailed out that this trial would be done March 26th. That's what they told them. So when the judge is going in and adding those 2 Fridays, he's giving them extra time to complete trial. He's buying them back 2 days. 2 days can make a big difference in getting a case done. So, a number of you have asked when this case is starting. The part that we can watch starts February 23rd. So where are we at the end of the day today? As we head into the Kouri Richins trial, which is truly beginning now, the Kouri Richins trial is taking all of the 1,700 plus jury surveys. Those were mailed out, they completed them, mailed them back. From that group of over 1,700 surveys, the court and the attorneys have sat down and said, we need to take these out. Individuals who cannot be on jury duty during that time because they're traveling. Individuals who are like, I know everything about this case. Let me tell you about Docket 214. I have opinions and more. All of the attorneys are going to go through that together. They're going to reduce the number of surveys to a jury pool. And then they are going to start bringing jurors in groups in the veneer or the pool to start to narrow it down to pick a jury of 8 deliberating jurors, 4 alternates. No, on this case, Utah does not deliberate with 12. 8 jurors, 4 alternates. Jury selection is scheduled to start on Monday, January 10th. The court has indicated that they are not going to run jury selection stuff on Fridays. I imagine that until we get to opening statements, the judge is going to use Fridays the way that the judge did in Depp Heard. Judge A used Fridays to go through motions, to prepare what needed to be cut out of depositions, etc. So I imagine the court will use that as working time or to handle their other cases, because even though court is going to be in session for trial, the judge still has a full docket. And oftentimes judges will use that day off to handle other motions and keep other cases moving along. So the jury selection is scheduled to take about 2 weeks. That's how long the judge has set aside for it. And opening statements should be February 23rd. The defense is still trying to get all communications between the prosecution, between the investigators, the sheriffs, and everybody else, and any potential witness that they're going to call in this case. The judge hasn't ruled on that yet, and the state's response is under seal. Funny enough, the defense exhibits were also under seal and then provided to the media. So why did you seal them? So we've not seen the state's response to that. We do not know what the state's response to that is, and there's no rebuttal in the media to the headlines that, the defense is alleging that the prosecution is intimidating witnesses or that investigators are intimidating witnesses. There's no rebuttal to that because it was leaked. And I have very strong feelings about that. If you didn't want to seal the documents, don't seal them. But if you wanted to seal them, don't provide them to the media. That's it. There are some pretty simple choices there. I imagine that the judge will deny that. I'm curious if the prosecution will bring up the defense's providing of that information to the media. I imagine that they should. If the court were to take that up, it would be something taken up after trial. The defense is not going to get admonished, sanctioned, or anything like that by the court before trial. Now, the court might say, what are you doing? Don't do that. And it is wild to me that on a Sunday, the defense is filing that motion and providing it to the media, yelling that the sky is falling and the prosecution is intimidating witnesses and everything is terrible and they need all the communications. And then turning around a couple days later and being like, but Your Honor, we don't have an adequate jury pool because they've all heard about this case. And the court denied that when they were in court Monday. I have to wonder if when they were in court Monday talking about the juror questionnaires, this came up. Very curious if this came up. Do we know? No. Might we know later? Maybe. We're going to have to wait until the end of this case to see some of the things get unsealed. But there are some things I'm very curious about that have happened in this case. And it's all under seal. So we don't normally go back through a docket after trial, but we've followed this one so closely since the beginning that there are things I will go back and look at on the docket, including why one of the defense attorneys needed to get their own defense attorney. Do we know why? No. But I want to know why. I have so many questions. When exhibits are sealed regarding like coroner's reports and medical records, fine. But there's some other stuff going on in this case that I really want to know about. So I expect that jury selection is going to begin as scheduled. I will keep you in the loop. If you do not have the Law Nerd app, now is the time to get the Law Nerd app. It's free on iOS and Android. We built it for you so you could stay in the loop. We are going to be in live trials sooner than I can even anticipate. And we are going to be in trial. And what we've seen of this trial is not everything that the prosecution is bringing to light. Yes, of course, there will be some days that is just an officer sitting on the stand going, yes, we recovered this from this location and then we booked it into evidence under number this. Sure. But there's going to be some stuff that we haven't seen yet in this case, and I am very interested. And maybe we can try to figure out who the witnesses are that don't want to be there. Because that's probably going to be pretty obvious when we get into trial. So y'all don't have to wait very long. You don't all have to wait very long for a new trial. It is just around the corner. We are going to go to court on a few other days between now and then. If you want to catch up on this case, we have a pretty thorough playlist on this case here. I think I've read the walk the dog letter like 17 times at this point. And we have the moment in court when the prosecutor actually asked a witness on the stand if they were familiar with Docket 214, because every law nerd on the internet knows, or as the law nerds on the internet know, the walk the dog letter. That happened in court in this case. Hi, Mr. Bloodworth. We're very interested to know if the defense gets in trouble for leaking documents. We really want to know.
Docket 214, but every law nerd on the internet calls it the walk the dog letter.
He's not wrong. Those are just facts. Look, the law nerds are a big fan of justice. The law nerds do not like fuckery. The law nerds don't really care which side is pulling fuckery. We'll call it out. I don't care which side of the aisle you're on in court. I don't care which side of the V you're on. This V, that, I don't care. Fuckery's fuckery. We are going to call it out. And I'm very curious. So I want to know. I want to know. We'll see how this trial goes. I'm curious. Trials are unexpected. But I really don't like sealing things and linking to the media. I'm really having a hard time with that one. I'm just like, ugh. And this case, there's been a number of us that have been covering this case since the arrest of Kouri Richins and kind of the court proceedings on that. But I imagine we will start to see conversation about this case really ramp up like midway through the prosecution's case. And then if we get closer to, is Kouri Richins going to testify or not? For those of you that are newer to this case, remember, EDB attended the court hearing virtually, but EDB attended the court hearing when they were scheduling this. And the defense said, we're going to need time because the defendant is going to testify. Can that change? Yes. Can a defendant change their mind? Yes. But the defense told the court, we need time because my client is going to testify. And she kind of has to. Because if the defense's argument is the victim OD'd, he took something and she came into the bedroom and everyone's worst nightmare. You find someone who is non-responsive and call paramedics. That is a nightmare for anyone. No one wants this to happen. Anyone who's had this happen to them, it is never going to leave you. It is awful. But to put that defense forward, it's going to be very hard to do it if she does not testify. And the prosecution's going to bring in those really tricky text messages with her lover, her side piece, her Sancho, where she's talking about how hard it is for them. I mean, because Eric's like still around. We learned that from Brendan Banfield, everybody. I mean, you can't really thoroughly pursue your relationship with your side piece when your spouse is still around. It's horribly inconvenient, he told us. Because apparently the women are just, chasing him around Discord. Sure, Jan. But he testified that it was really hard to build his relationship with Juliana because Christine was still around. And we've got those text messages from Kouri Richins to her paramour, as the prosecution refers to them in the filings, saying, I know, baby, I love you. I know how hard it is. Just hang in there. Till Friday. Awfully fucking specific that your husband is non-responsive Thursday evening, early hours, 3 a.m. Friday morning. It's so weird. How in the world did you know that your husband was going to OD when you had no idea that he did anything other than a weed gummy? Also, can we all leave weed out of this? I mean, for fuck's sake, stop it. But just hang in there. I'm going to have to find that part of the hearing so we can cover it again. I've forgotten which hearing it's in. It might have been in the preliminary hearing. I need to find it and make a note in my notes. So what's she going to do with those texts? Is she going to testify? No, I meant I was going to tell Eric I was leaving him on Friday, because I bet that's what she's going to say if she testifies. I was getting ready to leave my marriage. I was preparing to leave my marriage, and I was going to tell him on Friday. I'm sure that's what she's going to say. So we're going to have to wait and see. But the defense indicated to the court they need to leave room for the defendant to testify. She might very well change her mind. But she also did an interview from jail on her recorded line saying that nobody's heard her side of the story. It's incredibly unfair. These prosecutors are, big and mean, and they've totally got it wrong, and they've blown everything out of proportion. And oh my God, you guys, it's obviously a novel. It's not me telling witnesses what to testify to. And I just have to wonder, honestly, excuse me, I just have to wonder, is the defense optimistic that when they share these text messages and a motion saying the prosecution's intimidating witnesses, if they are just trying to kind of eat up the, the SEO on witness intimidation and witness tampering, because the prosecution accused Kouri Richins, I don't know why I said that weird, but the prosecution accused Kouri Richins of witness tampering by telling her mom and her brother what they needed to say before they walk the dog. But take vague notes so you remember. Remember, tell brother all of this. Tell him to go tell my attorney. Tell brother to go tell my attorney this so he can be a witness in my case. Is it just to get the witness tampering, witness intimidation out there before trial so when it comes up again that the prosecution accused Kouri of this, it's buried? Or is that giving everybody too much credit for thinking 2 steps ahead? Maybe it is, maybe it isn't. Let me know. I'm really curious what you think. I do not like sealing an exhibit and linking it to the media. If you want to try this case in the media, I don't really love that either. But if you're going to try this case in the media, then everybody's trying it all in the media. Hate it in criminal cases, it's going to happen. But if you are going to be leaking things to the media, don't fucking turn around and complain to the court that your client can't get a fair trial because of everything that's out in the media. Just come on. Your Honor, we can't get a fair case because of everything that they're saying in the media. We want the media to say the things we want them to say, just not anything else. Yeah, well, nope. Start a podcast if you want to tell your side of the story. Which, actually, I wouldn't be surprised that Kouri Richins starts a podcast from jail like fucking KUTV. That wouldn't shock me at all. Nope, wouldn't be surprised. Not at all. Let's get to some questions, y'all. Let's answer some questions. Emily, are we going to keep crashing out on this? Maybe. Emily's still a little salty. Let's get to questions, law nerds. Oh, that's right. Sorry, Miguelina. It's Suge Knight that has the podcast, not KUTV. KUTV is getting ready for trial. KUTV also wrote a book. I have conflated my people. Thank you, Miguelina. You're the best. Suge Knight's podcast. KUTV wrote the book. She definitely shouldn't have copied that idea. Writing a book didn't go well for KUTV or Courthouse Becky. I don't think it's going to go well for Kouri Richins. Remember, they did pretrial motions about the book and what comes in on the book. And she's also being sued over the book for improper use of likeness. That's right. That's right. All right. Let's get to some questions, some super chats. Thank you to everyone who gifted memberships. Welcome to all the new members. We had a members only yesterday. If you're a new member today, you can find that in the videos. You can see all the members only videos. You'll see it. Undercover Angel 11 said, EDB, you and I have been twins 3 streams in a row. Hoodies, same. I mean, I love the purple. I love the purple. To the stars who listen, oh gosh, I can't pull up. Something is going weird on the back end and I cannot grab this question. But to the stars who listen, oh my God, I missed the Run update. Don't worry. We will be doing a Run update. A do run. Don't worry. We'll get there. We answered that. Here for every Goodbye Earl callback to the 90s. I can't think of anything else when he's like, I really don't feel well. And she's like, just lay down and sleep. It's going to be fine. If I'm very interested to see how that all comes in. But if the jury believes that she poisoned his breakfast sandwich on Valentine's Day, and then, for those of you new to this case, I am not being hyperbolic in this. Sometimes it's hard to tell. I am not being hyperbolic in this. The facts, as the prosecution alleges them, are that Kouri Richins went to like a favorite breakfast spot, got a breakfast sandwich, poisoned it, left it for Eric Richins, and then texted him that she had to go do some work and have some cabinets hung in a house that she was flipping. Remember? Real estate empire. Crippling debt, real estate empire. And then she went to go be with her paramour. So, yes, have we changed getting your cabinets hung to a euphemism? Yes. But she leaves the sandwich for her husband, tells him she's going to hang cabinets in one of the houses that she's flipping. Something was getting flipped. And then when he says, I'm really not feeling well, if this keeps going, I might have to go to the hospital. She's like, just lay down and sleep. Those black-eyed peas. No, I'm sorry, that egg sandwich. And the defense is like, we don't even know if he ate the egg sandwich. Nobody knows if he ate the egg sandwich. Nobody knows. Nobody can prove that he ate the egg sandwich. How do you know? There's no attempted murder here. That attempted murder charge is going to be interesting to see how the prosecution proves it. Most attempted murder cases, the victim comes in and is like, that person tried to fucking murder me and failed. Unfortunately, that's not the case here. So trying to prove the attempted murder before the murder is going to be a legal nuance of this case that will be interesting. I'm interested to see how they argue it. I'm interested to see how they handle it. But the facts as the prosecution presents them include messages from Eric Richins talking about how sick he is. And then they're going to bring in experts to talk about what that means. So that's where we are on that. But yes, every time I hear that in my brain, it's just, why don't you lay down and sleep, Earl? Those black-eyed peas, they tasted all right to me. Ain't it dark? Wrapped up in that tarp. Not to make light of actual murder. Just get divorced, everybody. Just get divorced. Just get divorced. It's not worth it. Not worth it. EDB, can you please add Baby I Love You to the soundboard? I can't stop saying it. I love it. Proud to have been here when bruh was created. I mean, bruh was completely appropriate. And I don't know if I'll add it to the soundboard when I can just say it. Because every time I do, it reminds me of my colleagues as we were talking about cases at the DA's office and the amount of times that we would say to each other, yeah, but the witness is, baby, I love you. Or the defendant is on the jail calls and is like, I need you to, take this gun over to my mom's house. Baby, I love you. It comes up quite a lot. And in the last case and in this case, there is a strong, but baby, I love you component to the case. Because absolutely, Brendan Banfield was like, Juliana, baby, I love you. We're going to have babies. My mom's going to pay for your lawyer. We're going to make sure you have beef sticks and noodles and calls home. What did the defense call them? All the luxuries of life in custody? Was enjoying the comforts. I don't think he was in love. I think he was trying to keep her on side, but who knows? We're going to need to go through some of those letters. I don't know if we'll ever decide. We might need to go to the letters and see if we can decide. Is he trying to keep her on side? Or somehow is he all of a sudden like, I have never known love like this. All of a sudden, I have just been hypnotized. She just batted the eyelashes. And he was like, I am struck dumb by love. Or is he like, you know what would be better? if I was less involved in all of this, because hiring someone to murder my wife is definitely going to trace back to me. So who else could be the steps between the links in the chain, if it were, or the train cars, depending on what analogy you're using to try to distance the person who wants the murder to happen, the person that's making the murder happen? How much distance can I put between me and doing this? And does Juliana help in that equation? Thank you, Elizabeth. Get in the car. For the 10 gifted memberships. I hope that wasn't, I hope the get in the car Elizabeth joke was not intimidating in any way. I feel like now we need an asterisk before the defense is going to be like, she's intimidating her own law nerds. She said, get in the car, Elizabeth. She's being intimidated. Baby steps. I was subpoenaed with all the info. They never talked to me at all. Is that typical? Yes. They had no idea of my knowledge. It was a murder trial and they ended up taking a plea deal just before trial. Thanks. Yes, it happens. Yes, it happens. It's not ideal, but yes, it happens. Generally, if that happens, they might take 15 minutes before you testify and are like, hey, we're going to call you to testify. It's our understanding you were there this day. Is that correct? Yes? Okay. Tell the truth. We're going to ask you some questions. It happens. It's not ideal, but it can happen. They also might have subpoenaed you knowing that it was probably going to take a plea deal and that it was just a slow plea. There are some defendants that you can tell the second you bring in a jury veneer, they're going to be like, I'm done. Tap out. I'm done. Give me the deal. I want the deal. And if they had a sense that this defendant was going to take a deal the second the jury came in, it might also have been it'll be fine. We'll talk to you on Tuesday if need be. They might have known that that was coming. And that does happen. I was kind of annoyed sometimes. I was like, excuse me, I am ready for jury selection. I have on my jury selection suit. I have my hair done. I have enough outfits for exactly 7 days of trial. Can we please I am already in the uncomfortable shoes. I am prepared. Can we just do the trial? Please? No? Yes? No? Fuck. But you know what? If they want to plea, it saves everybody a lot of time and can put the witnesses in a much better place. So, Lauren, thank you for the gifted memberships. Michelle, thank you for the gifted memberships. Thank you so much. Taylor said, I do hope the egg sandwich had bacon on it. One would hope. I think we're going to hear more about it because the defense's argument on that seems to be like, who waits 2 hours to eat an egg sandwich? Ma'am, have you ever met anyone with ADHD? You might go get the egg sandwich, get home, do an entire another day, and then be like, wait, shit, did I leave the house this morning and get an egg sandwich? I totally forgot. Yum. It's going to be fine. It's going to be fine. Celtic Moon said, surgery tomorrow. Glad to have trial. Pickle? We can pickle at the end of the day. We can do a pre-surgery pickle. Hopefully it will be good luck. My device thinks I'm talking to it. I'm not talking to you. I'm talking to the pickle. We're talking to the pickle. Talking to the pickle. All right, let's get to, I am having issues getting to some of my older chats. Hold on, I need to take a screenshot of this so we can try to fix it. Among other things. Let's see. Electric Jen said, during Banfield's trial, all I heard was Maury Povich saying, and the lie detector test determined that was a lie. It would be hilarious on the soundboard. I've thought about it. We have seen numerous requests for that on the soundboard. Right now we're at survey says. However, that was a lie I will consider. Adrian said, decided to get my paralegal certificate because of you. Awesome. The world needs lots of great paralegals. Remember, they need you more than you need them. You can always find another lawyer who needs a paralegal. Look for a lawyer like Alessi who is like, I can do none of this without my team. Not a lawyer who's just like, excuse me, you are here to do my bidding. The real ones know that they cannot get a lot done without their paralegals. Find that real one. Also, find the real one who will always shout you out when you do things well. And on the occasion things don't go well, because that's always going to happen in life, they will own it. That's what you want to look for. Truly Laws said, literally just found out Bryn Weaver is coming to my city in June. I'm so excited. Got to get the whole series signed. That's amazing. I enjoy Bryn Weaver's writing. I really do. Really do. Heather said, aren't you happy the law nerds voted yes? I never regret it when the law nerds vote yes. Sometimes I question how we got here, but I never regret it. Even with this last trial, I had no idea Judge A was retiring. I had not paid attention. And then when we get to the end of the case and Judge A is like, anytime before July, because I'm retired, I was like, I'm so glad. The law nerds know. I just trust the wisdom of the chat. The law nerds know. JM said, I love that we know they watch you. Hopefully they are understanding that the things I take issue with, I will always take issue with both sides. When I am reading a motion, I am not reading the motion like, oh, I'm on your side. I'm reading the motion like, oh, what are you doing? And then we will go to the good points or the not so good points. And that when we have a little fun with the attorneys, look, they get paid enough to be there. This is the job that they chose. And when we get annoyed, sometimes we just can't help it. Sometimes I think I get annoyed too easily. Sometimes I don't think I get annoyed easily enough. But the chat lets me know if we're on the same page or not. And look, Tyrone let me know. Tyrone said for maybe the first time, I think I disagree with you, which is fine. We can all disagree. It's why juries have people talk to each other, because we can all disagree. The investigator is being deliberately vague so as to imply that if the witness doesn't agree to an interview, they risk losing immunity, which I'd find intimidating, which is completely fair. It's completely fair. I don't know what went before. And remember, I am looking at this through the lens of I have done this job a lot. But Tyrone, you're totally right in that the witness is not looking at this through the lens of I have done this job a lot. I don't fault the witness for how they feel. I don't. I fault the defense, who has also done this a lot, for looking at that and then calling it intimidation, when the defense could just as easily say to the witness, you have the right to not go to an interview, but you cannot ignore phone calls and be unresponsive, or they will send the sheriffs to give you a ride to court. They can have that conversation with the witness and say, if you don't want to be interviewed, don't be interviewed. You've told them you don't want to be interviewed, but it's fair because my perspective is this is my job. And that's not a perspective that the witness has. I get frustrated that we don't have the rest of the context. And I am concerned that there is context missing. But it felt pretty neutral to me, but I understand that that might not feel neutral to the person who received it, for sure. Tara said, thanks for 3 awesome members, the awesome members only yesterday. If you aren't a member yet, it's really worth it. Well, thank you to the shout out for the members. I very much appreciate it. We have a good time. I'm going to try to do another members only this month as best I can. We're just going to have to keep on the schedule to make sure that we can. So, J. Michael, good to see you. Idea for post-stream newsletter, name the docket. We do links to the streams and what have you in our weekly newsletter. We do have a weekly newsletter in addition to the app, but we could put a docket section up in the app. It's facilitating all the downloads and making sure that files can't get corrupted that I haven't spent enough time thinking about, but we can do that. I try to put them when the media provides them in the description as best I can. Lisa's gifted 5 memberships. Thank you for the gifted memberships. Took 15 and deleted 600 emails in one inbox. Good job, Liz. How many of you went through and deleted unread messages and emails during this stream because we were talking about it? I love that kind of forced, like, oh, I could do this right now. I promised at the end of stream that I would tell you how many unread text messages I have. 148, y'all. We have 148. We have 100. That's hard to see. No, That's very hard to say. 100, that's 148. That's 100, that's 148. Sorry, chat, that's 148. I don't have alerts on my emails because it would stress me out, but that's 148. Yep. Long Island Hillbilly 4780 said, thanks for the great community. I'm learning a lot. We're always here to learn. We're always here to have a little bit of fun. And we're here to just figure out what the facts are. We don't like it when people try to tell us things are facts that they aren't. I don't like being told that it's like, no, it's really this. No, it's not. If it's open for interpretation, though, I'm here to have a conversation. Elias says 28 months. No one does it like you, EDB. Well, thank you. Powered by ADHD, pop culture, and a very vast music library. All right, Law Nerds, you are the best. I have got to go get work done for Team Baker because doing accidental trial means there was admin stuff I didn't get done. And I know that that's stressing everybody out. So now I know that I'm the one holding everybody up. So I need to go take care of that today. I will see you tomorrow. I will put up polls later. And I am considering going to court tomorrow with y'all for Charlie Adelson's appeal hearing. And we can talk about, well, it's really in line with our topic here of how the appeal court looks at we should have gotten a change of venue, but we didn't get a change of venue. Though it's a different jurisdiction, the arguments are largely the same. And even though we didn't cover the Adelson case here, I think because we covered Donna's case, the facts of the case are what they are. But that conversation at an appellate level that, hey, a fair trial was not had because of pretrial media and because a change of venue was denied, I think that's a really relevant and interesting conversation. So I will put up polls for you guys and see, and then we can go to court and watch that hearing together tomorrow. That hearing happened yesterday. Yesterday was Tuesday. That hearing happened yesterday, and we will see. All right, but I'll put it out and see what you guys think, and then we're just 2 weeks away from trial. Thanks, chat. I'll see you tomorrow. Make sure that you get the Law Nerd app so you don't miss a moment. And if you're ready for trial, buckle up. Start making a list. Start making your list of things you want to get done during trial. It's like, okay, we've got like at least 5-6 hours of stream a day. What are we going to get done while we're in trial? All right, everybody. I will see you soon. Have a good one. Law Nerds, take care. Have a good rest of your day. Bye. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android, so I can keep you in the loop. Because you never know when something's going to pop off. Thanks for being here, and thanks for being a Law Nerd.